Good morning, everybody. Happy Tuesday. Welcome to TCF Live. My name is Dan Soul. I will be your guide through our next 3 hours of a journey through Courtlandia. We will start in Michigan. Judge Middleton.
Paige Kerlin, and I still don't see her in here. So let's go with Haley Marciniak. Come forward, please. Good morning, Mr. Stickley.
Good morning, Judge.
My goal, yeah, stand right there at the podium. Thank you. I didn't give you that instruction. Keith, we learned we have 5 microphones and 4 inputs. So I think everything's plugged in. The witness microphone, I don't think is plugged in right now. Good morning. Are you Haley Marciniak?
Yes, I am, Your Honor.
File number here is 26789ST. Ms. Marciniak, you got a ticket for driving suspended as a second offense. Our most common offense probably is driving suspended or driving without a valid license. But when you get the second one, it becomes a misdemeanor punishable by up to a year in jail and a fine of up to $1,000. It requires that your license be suspended. They say this happened at 6:17 p.m. on April 25th. And 3 rivers. Now, let's take a look at your driving record. Doesn't appear that you have any unpaid tickets. All right, thank you. You have 0 points, but you are suspended. You had several old unpaid tickets when they used to suspend you for not paying tickets. That might be part of your problem. Are you doing anything to try to get your license back?
So right now, I'm just working and I kind of went through like a little hard patch but I'm back on my feet and I have a 7-year-old daughter, a single mom, so I'm just been working and I plan to go downstairs today and make a payment. So.
Okay. Well, there is no downstairs anymore.
Oh, well.
It'd be right here.
Okay, yeah.
All right, this is under state statute. Now let's talk about this. Driving suspended second is punishable by up to a year in jail. No one, I think, in the history of the world ever got a year in jail. Well, they did. A guy named Frank Butts got a year in jail multiple times from Judge McManus because he had like 19 driving suspendeds. But rarely does anyone get a year in jail, and often no jail. But the lesser charge is a misdemeanor punishable by up to 93 days in jail and a fine of up to $500, but it would still require that your license be suspended. She didn't give me a breakdown. It showed me that you owe money, but you'd like you to check in with that. Mr. Stickley, I'm not quite sure what to do with this. Set a pretrial at a month from now?
I would think so, Your Honor.
Where are you working?
Goodwill in 3 Rivers.
Good for you.
I've been there for 6 months, going on 6 months on the 15th.
Well, thanks. I needed a little more to do today. Okay, thanks. Set a pretrial for about a month out. My apologies to Judge Pattison. I'm going to be stuck in here for a while. Set a pretrial for June 30th. 8:30 with the prosecutor. Bring proof of payment. Oops.
So real quick, while he racks up the next contestant, Tim, thank you for gifting 5 memberships. I very much appreciate that. Thank you so much.
Tuesday. This would be an ordinance case, but because it is punishable by up to a year, it's become a state statute case.
What does that mean then?
Well, it means that the state county prosecutor has authority over the case rather than the city attorney. But what I want you to do right now is go out to the calendar and check with the ladies out there and find out how much you owe.
Okay. Thank you.
All right, thanks. Our interpreter has joined us. It slows things down, but let's do Paige Kerlin.
Kerlin.
Good morning.
Good morning, Your Honor.
This is file number 252665FY. It's a 2-5 case. It was authorized by the prosecutor last winter or December, I think. And that didn't get served. We're gonna ask about that. But, find it. You're charged with a couple of counts. Embezzlement over $100,000. It's alleged that you embezzled more than $100,000 from Buckle Brothers Construction. That is a felony punishable by up to 20 years imprisonment and a fine of up to $50,000. Second count is embezzlement over $20,000, but less than $50,000. That's a felony punishable by up to 10 years in prison and $15,000 fine. And then the first count is plain old forgery that alleged that you forged a check at Huntington Bank. And that's a felony punishable by up to 14 years imprisonment. I had a little, according to the affidavit, you're alleged to have taken a very large amount of money. And this is a felony. And punishable by serious consequence. Now, they issued the warrant way in December, but you didn't get arrested until May. How did you come to get arrested for this?
I was at a funeral and there was a disagreement that happened and I gave a statement to the police. I didn't realize that I had a warrant. And I just gave my name and then they came and got me after that. And took me to
So
jail.
they never came to your house to try to arrest you or anything? They just arrested you by accident?
No, Your Honor, yes, it was.
All right, well, it alleged you took almost $700,000. And that's a lot of money. Are you able to hire an attorney?
I'm not.
Or we saw a brief review of her of the qualification form, it would appear at this time that it would be appropriate to appoint counsel.
All right. All right. Are you still live on Peeler Street?
No, Your Honor.
Where do you live?
I'm living with my parents right now in Marcellus.
They didn't put the dates on here, but I think it'd be May 26th. For the pre-exam conference. 8:30. And prelim would be June 2. At 1 o'clock. Appoint an attorney. All right, you can't leave the state of Michigan. They set a PR bond in this case, I think, before they really knew what the deal was. $7,500 PR, all the bond conditions remain in effect. I'm gonna have the bailiff take you out to the court office. They're gonna give you your court appointed attorney's name and number. I want you to contact that attorney and discuss it with them prior to the date of May 26th, which is what your pre-exam is. There's probably lots of paperwork, bank statements, other things that they'll need to go over. These embezzlement cases often can be very involved. But there's a lot at stake here. And so I lost my court officer, but I want you to go out to the counter and we will get an attorney appointed to represent you. All right, you're good to go.
Thank you.
Make sure you.
So good morning once again, everybody. It's TCF Live on a Tuesday. Hopefully not a second Monday for at least most of you. My name is Dan. It's good to have you here on this 3-hour journey through Courtlandia. So yet again, another financial crime. We're seeing more and more of this embezzlement, this stealing. A lot of that going on right now. And matter of fact, tonight on Sidebar, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel, we're going to cover the sentencing that we saw yesterday of Mr. Kaufman, the funeral home director, who took about $1.1 million from people who prepaid for their funerals. So join us for that, because that will be a spirited discussion, no doubt. Let's change it up a little bit. Let's go down to Lake County, Ohio. Judge O'Donnell, who apparently is having a casual Tuesday, no robe today.
Would be inappropriate at this time based upon the request that City of Kirkland follow the law as the injunctive remedy. And given my reading of the rules, it is not necessarily clear to me exactly what the timeline would be to brief that, and I thought it would be best for the parties to come together and ask exactly what the remedy is, given that we are still in the process of seeking administrative approval on the applications of the co-defendants.
Okay, so let me give you my understanding of where things are at. Mr. Zeman's client, Mr. Lancar, correct?
Yes, sir.
Is seeking to build, what, 5 condo units?
5 duplexes, Your Honor.
Okay. Side by side?
Yes, sir.
I assume? Right. In a historic district, which, in the historic district in Kirkland, is that right?
I believe that's their overlay, correct, Your Honor?
Okay. And in order to, right now, I think, from what I understand, and correct me if I'm wrong, that residential is not permitted in that district?
Conditional use for what this
Okay.
residential development is, correct?
So, so your client went before the BZA to get a frontage variance, is that right?
Two components, correct. It's basically a bowling alley lot currently. There's frontage on 306, and there's a structure on that. It's the back acreage that's to be subdivided, and since the subdivided rear parcel won't have any frontage, the purpose of the variance was to permit that lot split.
Okay. So did BZA approve what your guy requested?
Yes, Your Honor.
Okay. There were some notice issues brought up by Mr. Walter as to the various TCE entities. Are the members all the same in the TCE entities?
Yes, Your Honor.
Okay. So then I think it goes before the Planning and Zoning Commission for the lot split issue. Is that right, Joe?
Well, the Planning Commission would issue the conditional use permit for the residential development. The variance was granted, I believe, by the Board of Zoning Appeals.
Okay. For is also as to the split?
To create a non-conforming lot, correct.
Okay. So was the conditional use permit approved by Planning and Zoning?
It was approved, subject to final development plan, and so that has not come before the City Council yet.
Okay. Has the plan been submitted? Who does the plan get submitted to? Planning and Zoning first?
Correct. And the BZA, I don't know if the BZA had a look at it or not, frankly, but initially the Planning Commission takes a look at it.
Okay, and they haven't approved that yet?
The Planning Commission did approve it. Correct.
Okay.
But I believe, and I don't want to speak for the City of Kirkland, they view that as a preliminary approval, not a
Right.
final approval yet.
Okay. So, and it's not gone before council yet?
Correct, that's
So-
the next step in the process.
And it's your position that none of that matters until council approves what had been done by their commission?
Correct. There is no, while the conditional use has been preliminarily or conditionally granted by PCC, it has not been issued, and therefore there has been no harm yet that's befallen the plaintiffs, if ever.
And can it be issued without council approving it?
No.
So where are we at with regard to whether we are here too early?
Well, Your Honor, with all due respect, the lot split and the variance were granted without any ability of my client to contest that.
Okay.
And if you look at the section that's in our preliminary injunctive motion at page 4, the Kirkland Code of Ordinances 1275-04 specifically states that conditional use permits, there's three issues we have. First, the variance. We never had a chance to object or go after that.
And is that because only one of the entities got notice?
That was none of our entities got notice.
Well, there were a number of times it was continued or delayed, right?
Those were other hearings. Those were on the conditional use permit. They were on the lot split. They were on, the variance did get continued once, but we still didn't, according to the verified complaint, still did not get notice of that. And so the variance was never given, my clients were never given the opportunity to come and contest that. And the case that we cite, which is at El Hassan.
Hold on, was notice provided to any one of the TCE entities?
Yes, it's our position that it was, and it was continued once the plaintiffs made us aware that notice was not provided, so they were.
On the issue of the frontage and the split?
Correct, Your Honor.
Okay, go ahead, Mr. Walter.
Sure, and so the case that we cited was El Hassan, ALIHASSAN versus Alliance Board of Zoning Appeals. While it is a 5th district, it's pretty on point that if you don't have the ability to contest certain issues, then the administrative procedures don't really apply. And our position is from the variance to the lot split, and then we now have a conditional use permit that we did appear at. My involvement didn't start in this until January. And to the city's credit, I'm now getting emails as to when the hearings are from their assistant law director. We weren't able to contest any of that. And so this lawsuit was filed because the groundwork of that, which was the variance, is the capstone of everything else that goes forward. And so the way that the variance ordinances are written in the city of Kirkland, there were some difficulties that had to be proven, and there was absolutely nothing put on the record. We would have opposed the granting of the variance, which would have stopped this project in its steps. And that's,
If Kirkland goes ahead and puts that on their agenda to approve what BZA and what planning and zoning did, and they have a meeting, and your client's there and objects to it based on he never got notice of the BZA actions, which they contest, but if they then approve it, then do you have an avenue to challenge that?
we would be able to challenge that, but again, the procedural irregularity was the granting of the variance, which we never
I
had the ability to.
understand what your argument is, okay? I'm questioning whether we should be here until such time, because there is no variance granted, right?
The variance was granted.
Well, I guess we're speaking two different languages. Nothing is effective until council approves it, right?
No, the site plan is what is pending, not the variance. The variance has already been granted.
Does council have to approve variances by the BZA?
No, so the variance that would allow a lot to not have frontage was approved.
Okay.
Then the lot split happened, that was also approved. However, in order for my co-defendants to actually build and use that property as they suggest, it needs to go through the full conditional use and site plan development process, which culminates with city council approving the site plan.
What's the value to Mr. Lancar of the variances by the BZA if the lot split or if the plan is not approved by council?
Well, in regard to the lot split, that's what's allowing for the residential development. That's our purchase agreement. In terms of the conditional use permit, I mean, there's no project without the CUP.
Okay. So does he have the ability to utilize what the BZA's approval without a plan approval by council?
No, the lot split would just allow for a non-conforming lot. There's an easement agreement, of course, allowing for ingress and egress through the remainder parcel to 306, but it's just vacant land at that point without an approved site development plan.
Okay. And Mr. Mitchell, your client sold to Mr. Lancar the property?
My wife,
Right. Who's your client, right? In
yes,
this
and
situation? Okay.
she's in the hospital right now.
Okay. So we've got your motion for judgment on the pleadings, essentially saying that it really isn't ripe yet because what Kirkland hasn't taken action on the plan approval, right?
That's the large gist of it, Your Honor. There are a couple other arguments, including that two of the landowner defendants are inappropriate as they're outside of the notice requirements. So even if they didn't receive notice, they were never supposed to receive notice.
Okay, what is the notice requirement?
I will get them confused in the moment, Your Honor, but one is 300 feet, one is 500 feet. And they're outside of the 500-foot
Okay.
limit.
And Joe, do you know the specifics on the 3 versus 5?
Actually, no, Your Honor, not off the top of my head.
What of that, Eric?
I believe the conditional use permit is 300 and the variance is 5, but I could be wrong, Your Honor.
Okay. And you have not responded to that yet? or
No,
did
Your
you?
Honor.
Okay. And when is your response due?
We filed a motion yesterday for a short leave based upon I was in trial last week or 2 weeks ago and catching up.
Okay.
We just filed that.
Okay.
Otherwise, it would be due, I believe, Thursday, but we asked for a short leave.
Okay.
And Your Honor, we have no problem briefing that and then letting the court rule going forward. I think the judgment on the pleadings plays heavily into the injunctive relief as well. And then there's Mr. Mitchell's motion to stay, which, we didn't oppose that, Your Honor. We've opposed his motion for dismissal or more definite statement. Because you're right, there are a flurry of motions pending. There's the motion to dismiss and motion for more definite statement by the Mitchells, the motion to stay by the Mitchells, and the motion for judgment on the pleadings by the city, and then our motion for preliminary injunction.
Okay. What was your motion to stay, Mr. Mitchell? Remind
Well,
me.
it was in hope that you would roll before we had to do substantially more work.
Okay. Well, I think my inclination is to rule on your motion, okay, before we do anything else, because your injunction and declaration is simply that you're asking that I make Kirkland follow their ordinances, right?
Which started, you're correct, Your Honor,
Right.
which started with the granting of a variance
Right,
that
okay.
should not be the capstone of this.
So I don't think they're opposed to following their ordinances. It's a
Well, they haven't been so far, is our
Well,
contention.
that's why we're here, okay, because you say one thing and she says another, and these guys are caught in the middle, so. So what I'm gonna do is I'll look at your request to extend your time to respond to that. Did you guys, Mr. Mitchell, are you intending to respond to the motion for judgment on the pleadings?
No.
Joe, what about you?
Oh, there.
Okay, so I'll wait for your response, I'll give you a chance to reply, and then I'll rule on that, and we'll go from there, because that seems to be the first block here before we do anything else. Does anybody disagree with that?
I do not, Your Honor.
No, but if I may, Your Honor.
Yeah.
Plaintiff has asked until June 11th. It is very likely that the city council hearing on the site plan will happen before then.
When is it scheduled for?
It is not, I don't think that it is actually on the schedule yet, but it could be as early as next week.
Can you grab the law director?
I can, but I can tell you that the PZC issued a resolution sending it to city council last night. So in terms of when city council puts it on the agenda, I will find out, but I'm happy to go get him.
Okay. How are you enjoying your less hectic life?
Well, it's getting there, Judge. I keep telling I'm trying to work like part-time, 20 hours a week, and I'm still putting in 40 hours, so.
With them still? With Menor still, or are you done with them?
Oh, I
You're
was,
done.
yeah, March 20th was my last day there, so 23 years was sufficient.
Yeah.
More than sufficient.
Morning, Judge.
Well, we were just talking about the timing of council's action on the plan.
Yes.
Do you know?
So they met last night, planning and zoning met last night, and it's my understanding that they passed that resolution, which then refers the final development plan to council per our zoning ordinances. That'll be in the form of a resolution, and they'll have an opportunity to review it. I believe it'll be on Monday night.
Next Monday.
Correct. Then it's up to them as to whether they want to approve it, have modifications, or deny it. They can have it go for 3 readings, or they can waive the 3 readings as well.
What's their practice in a situation like this? What's their practice
Well,
as to waive or have all 3?
So I'm trying to remember, the only other case we had, which was similar to this, was the Coca property about 5 years ago. And I believe they actually called a special meeting to consider that approval and waived the 3 readings. I could be wrong. I don't recall that off the top of my mind. But the waiving of the 3 readings, it's hit or miss as to how they wish to proceed with it. So they don't always waive the 3 readings. Sometimes they let them go 2 or 3 readings. I can't predict that.
Okay. All right, well, they're gonna do what they're gonna do. I'm not gonna suggest they do something or not do something. I'll just rule on what's in front of me, and we'll go from there. If they approve it, then we'll see where that puts us. But I'll rule on your motion for the extension of time,
Thank you, Your Honor.
and we'll go from there. So nobody needs to respond on the injunction. So let's just hold everything.
We've already responded,
Okay.
I believe, on the injunction.
Okay. All right.
And we would request that you roll on our motion the same time.
The motion to stay?
No, not the
Or what?
motion
The
to
motion
stay, the
for more
motion to
definite?
dismiss.
Okay.
Because it's our position that we're in this just nominally, and there's no actionable, or there's no cause of
Yeah, where does-
action
where do
expressed
they-
against us.
Where does Mr. Mitchell's client fit?
They were the property owners, Your Honor.
Okay, I know, but are they, you're challenging the process by which you got here with
Right.
Kirkland, right?
And the purchase agreement is conditioned upon all of the approvals, and it can be withdrawn at any time after, if all the approvals are not obtained.
Yeah. What I expressed in one of those documents is what's really going on here is Mr. Christopher, Mr. Walter's client, has sought to buy our property since at least 2002. And the reason he didn't buy it is he didn't want to pay a fair and marketable price. And he wanted to add on to his party center by putting tree houses and/or RV parking in for his weddings and stuff like that. And that's all that's going on here. It's a made-up case on the part of the plaintiffs.
I would bet Mr. Christopher has a different take on it, but you know, that's
He
why,
might, but it wouldn't be accurate.
that's why we have courts.
Right.
So I'll take, is everything in? Did you respond?
Yes,
to
Your
these
Honor.
motion? Okay.
Yeah, the motion to dismiss is fully briefed.
Okay. All right, so I'll take those up and we'll go from there. Anything else? Anybody else?
No, Your Honor.
No, Your Honor.
All right, thank you.
Thank you, Your Honor.
Alrighty, friends, a little bit of a different look at Judge O'Donnell, not just because he didn't have a robe on this morning, but that he wasn't handling some kind of felon and swearing at him the whole time. So, you know, always good to experience new things. So, real quick, we're going to go to Judge McNally, but before we do, I want to show you guys something. As I was going through courts, I was looking at Licking County, Ohio, and I don't want to go there for this hearing because it was done with a translator, very hard to follow, but I captured what the defendant was wearing. So take a look at this. For those of you on the podcast side, what we're looking at is a white hoodie, and on the back is artwork of a scantily clad woman wearing a bandana around her face to hide her identity, who is running away while holding a bag of money. Now, of all of the different things we have seen people wear in court, this one might actually take the cake for me. It's like, you know, one of the rules of crimes is don't document or write down your crimes. This one almost documents it, doesn't it? It's just absolutely insane. Of all the things that you could choose to wear to court, something that actively depicts a crime is it's a choice. Let's just say it that way. It's most certainly a choice. All right, I just thought I'd share that because I thought it was hilarious. Let's go back up to Michigan, Judge McNally.
All right, your appearance, please, Mr. Leonard. Name, your name. All right, so your client pled guilty to operating while visibly impaired back on March the 3rd of 26. She was referred for a screening and assessment. At some point prior thereto, she violated the bond conditions on February 12th of 26. I issued a bench warrant, forfeited the bond, and set a new bond after finding that she had consumed alcohol. I told her at one point that she'd better get into sobriety court. If she did, I wasn't guaranteeing I wasn't guaranteeing anything. But that I guaranteed she was not that she was going to go to jail for a lengthy period of time if she didn't get into sobriety court. And that's where we are. If you had a chance to review the report, any material additions, corrections, or deletions? Anything that you would like to say on her behalf?
Your Honor, when you probably picked up the part, you talked earlier last week, you know, talking about. Plan for sobriety. She had to be permanent, maintain that sobriety. And she is no longer in denial. She has a alcohol substance abuse problem. In Brooke, she's working hard as a realtor. She has 3 small kids. Applied with probation officer, some minor flips. She didn't apply on the order.
Okay, anything else? Ma'am, anything you would like to say?
I am taking this seriously. I have been going to therapy on my own. I've been seeing a therapist now bi-weekly. I am going to IOP. I take that very seriously. My kids are my why. I'm committed to this program. You would accept me.
John Cohen there.
Okay.
You had a job interview at DTE, but you haven't heard anything yet? And you're working at LPT Realty, and that's the only place you're working?
I'm sorry.
That's the only place you're working?
I have helped out a friend. She just opened up a restaurant. I helped her a couple of times, but outside of that, no.
What restaurant?
JT's in Trenton.
Why didn't you tell your probation officer that before?
I'm sorry.
Why didn't you tell your probation officer that before? And why did I have to ask questions to find out that you were working at JT's?
I just helped them out a couple of times. I'm not like fully employed there. I want to be.
Okay, hold on.
I'm not able to do real estate full time right now.
Why didn't you tell me that?
I'm sorry.
Why didn't you tell me that? You got 4 drunk drivings. You have no business working in a bar. And I don't mind telling you, if I had known in your situation, now I want you to understand, I've allowed people to work in bars and restaurants before that are in sobriety court, but these are under different circumstances. You had 4 drunk drivings. You had a 271. You violated your bond conditions. You've been working at JT's a lot more than a couple times. Don't tell me that. That is not truthful. I know too many people, young lady. I know too many people. I know too many people. Don't tell me you've only worked there twice. You said a couple times you helped out a friend and you didn't bother telling anybody your name. So I want to know, because you and I talked, because you had a conversation with her. I want to know, I want you to state for the record what she told you. Then tell me when it was.
So the appointment was on April 20th. Found out this meeting with you on April 20th. That she was working at the bar. So at our appointment on Friday, that same April 24th, we had just been going over the screening. I asked if there were, anything new to add. We talked about employment and how she is supporting herself due to backing off real estate, and she said that she was supporting herself through her savings.
She didn't say anything about working at JT's.
No.
Your Honor, can I tell you what?
Yeah, you can tell me whatever you'd like, and I'd make it really good. I cannot have people in a sobriety court that are not being upfront and truthful with me. I can't do it. I won't do it. It's not. You have no chance. You had no business taking a position at a bar, serving as a bartender and a waitress. None. Particularly without coming to me and asking me if that was okay, or at least bringing it up with your probation officer, and you concealed it.
I didn't conceal it on purpose.
On
I
purpose.
thought I opened the place and asked her if I could pick up some shifts there to supplement my income, because I'm not able to do real estate full time right now. I'm not full-time employed. I would like to be. I really need the money to support my kids right now. I know the people that work there and I'm able to get rides from them, so yes, I have picked up shifts there. And I stopped asking to bartend. I was only picking up the certain shifts.
Listen. I have to go by my gut. I don't sense that you're taking this serious. You violated the bond conditions. You had 26 late blows. You tested positive on February 8, 9, 10, and 11 for alcohol. Like I said, you missed 26 blows or they were late. You're not getting your AA logs to her in time. Listen. When I do this, I'm putting myself out there, okay? When I try to help people in felonies and this should have been a felony, like I told you, somebody dropped the ball in my view. I don't know why they didn't charge this as a felony. You got 4 of them. Grant, it goes back to 09, but you're only 38. You're only 38 years old. And you needed to cross every T and dot every I, and you didn't.
I have 3 children that I'm trying to raise.
You're gonna kill somebody. You're going to kill somebody. And I can't do this. I wish I could. The whole team agrees you need help. Ma'am, I can't take you. I cannot take you. Can't do it. I wish I could. I get so disappointed listening to people when I know that they're lying to me. This is not voluntary truthfulness on sobriety court in particular. There's no way I'm changing my mind, Mr. Longton.
Well, Your Honor, she was desperate because pending family law case, we received no child support and have overseen the child support until they need you. If you've been desperate, get forward. So all of us, she asked for a surgery. So.
Okay, 3 kids, I'm going to take care of myself.
I get it. I get it.
I have been married to I get myself into therapy.
You also, listen, I want to take you. I want to take you. No. I cannot. I agree you need help. I cannot do this. Ma'am, you should have thought about that before you got your first, second, third, and fourth drunk drives. They should have charged a felony. You had a chance to keep this to a 93-day misdemeanor with a minimum jail term, and you were not truthful, and you went to work in a bar, which I can't even think of a worse place for you to be working. I'm sorry. 300 fines, 600 costs, 75 victims' rights fee, $50 justice assessment, $60 screening fee, $225 in cost of recovery, and 61 days. Credit 1, serve 60 now, and you're going to serve 30 more days if you don't pay your fines and costs. And I will let you pay those at the rate of $50 per week. And I will start that beginning on August what's the first Friday in August, Lisa? Amy?
Could you possibly do this on weekends?
No. There's no way I can let her do it on weekends. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer. You should have thought about all these.
August 7th, Judge.
August 7th. If you need more time, you call the quote. We'll go on Zoom. I feel awful about this, probably as awful as you do, except I'm not the one serving the jail term. You're gonna have to, we'll let you make some calls, but you're in custody for 60 days. Yes, you are. And I'm not gonna let you start tomorrow because you weren't honest with me. And when people aren't honest with me, this is what's going to happen, particularly with something that's as serious as going out and committing 4 drunk drivings. You have no idea how lucky you got that they didn't charge you with a felony. I'm sorry, ma'am. Have a seat. That's it. Sorry, guys. Hyder Abdul Hussein Hassan, 260-827-965.
Get rid of the have seat. Well.
So just to pause real quick, I gotta say that, you know, for all the lecturing and everything that we hear from Judge Dad, you know, which is why we call him Judge Dad, the amount of times he like actually puts somebody in jail like that is incredibly rare. So you know you have earned it if you got Judge Dad to that point. I'm just saying, if you see it different, let me know in the chat. But she done messed up. Anyways, let's continue here with Judge McNally for a while.
Well, sir, come on up to the podium and state your name. Your name?
Hyder Hassan.
You're charged with a DNR fish game violation. They think that you were snagging or attempting to snag fish on April 9 of 26 at Hurock Park near Arsenal Road in Black Rock. You have the right to a lawyer. If you want one, I will give you one. You have the right to a lawyer, and if you want one, I will give you one. Would you like one? Sure. Do you understand English good?
Yeah.
Okay. So I'm just explaining the charge to you, and the possible penalties are up to 100 fines, 90 days jail, costs are all those. You tell me if you want a lawyer. If you want one, I will give you one. Today, free of charge, public expense. Would you like a lawyer?
Is it charged in jail?
I'm just telling you, I have to tell you what the maximums are. Those are the maximum penalties. I have to tell you them. I'm not sending you to jail on this. No. I don't usually go out that far, but I'm not gonna send you to jail. You want a lawyer?
Just charge the lawyer.
Okay, so, all right, so we'll proceed and I'll send you to the prosecutor. And if you don't like what he's offering you, you can come back and tell me, Judge, I want a lawyer. Fair enough?
Okay.
Is that fair enough?
Yeah.
All right. Did you sign, read, and understand the advice of rights? Yes?
Yes.
If you please, did you read it and understand it?
I really understand.
You got to keep your voice up for me, nice and loud. Speak into that microphone. I'm getting hard to hear.
Yeah, I really understand some stuff.
All right. You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. This is a misdemeanor. You have the right to a jury trial. You have the right to.
Whose phone is that? Hello.
You gotta take.
The signs all over the doors.
Come on, guys. No more phones, please. I don't know what I have to do. Shut your phones off or go out in the hallway and put them in your car or put them in a locker or leave them with a friend, whatever you feel that's the safest. But I cannot have people coming in here with phones every day. All right, listen. You have the right at a trial to remain silent. They can't compel you to testify. You have the right to remain silent. You have the right to testify if you want to. You have the right to bring in your own witnesses that will help you. You have the right to use the subpoena powers of the court, where I will sign an order for you to bring in your own witnesses. You have the right to cross-examine the prosecution's witnesses. If you plead guilty, you're giving up all of those rights. You're waiving the presumption of innocence and the requirement that you're guilty beyond a reasonable doubt. Do you understand?
Yeah.
All right. Guys, you still wish to waive your right to a lawyer? I can't hear you. I cannot hear you. You got to keep your voice up.
Yeah, so can I explain?
No. You can't explain. This is just an arraignment. You can go explain to the prosecutor. I'll be glad to enter a not guilty plea. And I'm sure the prosecutor is going to be reasonable with you. But if she's not, or you don't think she is, you can come back in here and tell me, Judge, I don't like their offer. I want a lawyer. So do you want to do that? Enter a not guilty plea?
No, so, what was the charge like for?
The charge is snagging or attempting to snag a fish. That's what you're charged with.
Okay,
This happened at Hurock Park, according to the police, the DNR officer, on April 9 of 26. That's the charge. Do you want me to give you a lawyer?
no,
All right, I'll enter a not guilty plea. Somehow you posted, it looks like, am I right? He posted a $10 bond. Is that right, Amy?
Judge, yes, it looks like the conservation fee
Right,
in
right.
there, so he thought that was what he
All
should pay.
So listen, you cannot leave the state without the consent of the court. You cannot violate a law. You must appear in court as directed. I'm going to send you to the prosecutor. You will speak with her. Either way, she's going to send in the file. If you work it out, great. If you don't, and you don't like what they're giving you, then you come in and say, Judge, I want an attorney. Fair enough? Okay? So go out in the hallway. She will call you in. You will talk to her, and then you can decide whether you want to proceed like that. Okay?
okay,
Thank you.
thank you.
All right. Do I have Flat Rock ready over there, guys? People against Corey William Little, 23B 143090. 23F 240292. Your name, sir? He's muted. You have to unmute him, officer. Mr. Westmoreland, your name?
Good morning, Judge. Attorney Corey Westmoreland, appearing on behalf of Mr. Little.
It's still muted.
Mr. Little, would you please state your full name for the record?
Corey William Little.
Okay, officer, your name?
Sergeant Mitchell with Flat Rock
I'm
Police
sorry,
Department.
Sergeant. My apologies. Okay, so defendant still owes a substantial sum of money. He was sentenced by Judge Hassan on the misdemeanor back on July 20 of 23. He was sent a letter in May of 24. Amy, could you tell me how much he owes on each of these, please?
He owes 185 on the case ending in 090 and 399 in the case ending in 292.
What is he going to do here, counsel? I mean, he's had multiple opportunities. I hope he's got the money. It's been going on for 3 years. We've given him chance after chance after chance. If anything, we should be faulted for being so kind. So what is he going to do here?
Your Honor, Mr. Little does acknowledge that he does owe this money to this honorable court. He is a single father of a 2-year-old.
So is he going to plead guilty, or is he going to,
That's correct, Judge. We're prepared
is
to.
that what you want to do, Mr. Little?
Yes, yeah, that's okay, sir.
If you plead guilty to failure to pay $399, you could get 90 days. Do you understand that?
Yes, I have some.
I just want to know if you understand that. Do you understand?
Yes, sir.
And you
Yes.
you said 185 on the other one, right? Is that right, Is that right, Amy? Amy?
Yes.
Why am I getting, why am I
One
getting,
eight, yes.
why am I getting feedback over there? Why am I getting feedback over there?
It's from Flat Rock's jail, Judge.
It's from Flat Rock's jail, Judge.
Can you tell them to ask them to work on that, please, Sergeant?
Work on that, please, Sergeant.
I mean, I don't like to hear my voice that much.
I don't like to hear my voice that much.
I will let IT know about it.
If you plead guilty to failure to pay 185, you can get 1 day for every $10 owed. You could get 19 days. You can satisfy that in full by payment.
Satisfy that full by payment.
In full by serving the jail term, or in part by payment, and in part by serving the jail term. Do you understand that?
Do you understand that? Yes, sir.
All right. Okay, now, if you plead guilty again.
Now, if you plead guilty again.
Geez, that's driving me crazy. If you paid $85, you'd only owe 100 on the civil infraction. You get $10.
You get $10.
Credit for each day served. Do you understand that?
For each day served. Do you understand that? Yes, sir.
So you'd only have to serve 10 days. Do you understand that?
You only have to serve 10 days. Do you understand that? Yes, sir.
All right. Now.
All right. Now.
To the charge that you failed to pay 185 on the civil infraction, how do you plead?
Civil infraction, how do you plead? Guilty.
Did you fail to pay?
Did you fail to pay? Yes, sir, I did.
For the charge you failed to pay $3.99 on the drivewall suspend that was revoked, or that was reduced to allowing the licensed driver to drive, how do you plead?
Licensed driver to drive, how do you plead? Guilty.
Did you fail to pay on that?
Did you fail to pay on that? Yes, sir.
Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
Promise you anything to induce you to plead guilty? No, sir.
Pleas are accepted. You got a big problem here. Judge Hessen was kind with you starting back in November of 23. I was kind with you starting back in July of 23. You hadn't paid, we show cause you pled guilty to failure to pay $213. I said you would have paid $30 per week beginning July 23. These had multiple payment plans set up with you. I told you if you didn't have the money to come talk to me, and here we are 3 years later. I hope you have this money. If you don't, you got a big problem.
You got a big problem.
You have the money?
You have the money? I have majority.
Mr. Westmoreland, what would you like to say?
Yes, Your Honor. Mr. Little is currently living in Monroe. He is employed working at True Cuts LLC Lawn Care. He does acknowledge that he owes the money. Like I mentioned earlier, he is a single father. I would just ask for one last payment plan.
When he says he has the great majority.
When he says he has the great majority, what does that mean?
What could you make a payment?
What could you make a payment? I can pay like 150 at least today.
That's not the great majority. You owe the court $584, and you've had 3 years to pay this. And you've been given multiple opportunities.
I could probably come up at least like $200, $300, $400 today. I just don't know exactly what I have. When I was arrested in Monroe County, I had $150 in my pocket. So I'm just saying what I know I for sure have in my pocket.
When are you going to grow up?
Sir, I'm not making excuses. I'm holding 100% accountability. I know I was supposed to pay the money. Honestly, I just completed Monroe County probation back in May of last year, and I take care of a son by myself. I'm currently homeless, and I've been trying to get back in with that. I just want a place to live. I was staying in a hotel for the last 3 months with me and my son. So I work at True Cuts LLC.
Who takes care of your son when you're at work?
I have my mom. My mom takes care of him, and then I have like family friends watch him here and there. And then I also have to pay them out of my wages of part-time from that. So it just I'm trying my best here, sir. I'm not making excuses for it. I know I'm supposed to pay it, but I'm really trying my absolute best. I'm sorry, I could have paid at least $10. I could have paid something. You are right about that. And I apologize. My apologies for that. And yeah, I can pay a few dollars. I have $26 on me in my.
I thought you said
in my-
150.
my-
I thought you said 150.
No, when I was arrested in Monroe, I had 150, but my girlfriend was there, and that was the money we were using towards our rent for where we were staying at. So she had grabbed it. But
I thought you said you were homeless. I thought you said you were homeless.
I am homeless. I told you I just found a little spot to stay at. I literally just found it, and that literally was our first day.
I'm not letting
that's
you
the money that
go
we were gonna
pay
pay. So
$26. Okay?
okay, that's understandable.
Sergeant, let them
I'm
make
just saying that's
some
what I have on
calls.
me. But
Have them bring it to the police station.
Have
them bring it to the police station. John, text my court officer. When he's done that, he has the money there. And I will go out of my way to figure out a way to help him, but he's gotta grow up a lot. So you can text John and let him know, and we'll go from there. I told you to come talk to me. I don't understand this. I understand people not having the money. You never gave us the courtesy. You came in front of Judge Heston and apparently gave her a sob story on multiple occasions, and each time she gave you an extension. So that's it. Let us know when he's ready. He's gotta have a lot more than $26. No, what's your question, sir?
So say for instance, if someone could come in and pay like the $400 bond that I was supposed to be having, instead of paying that $400 bond, is it a way if they can pay like $300-400 on the ticket itself?
I'm gonna help you if you act like an adult.
Yes, sir.
Get them to bring you money, and I will work with you. But you can't do what you're doing here, okay?
Yes. So,
Any questions?
do I just have them bring it to the police station?
Yeah, have them bring it to the police station, or you can have them bring it up to the court. But you're in custody until you can come up with some money, and I will work with you. Okay? Good luck. Okay?
So
let John know
what
if
if
you
someone
would,
can pay my
Sergeant.
bond?
And please do talk to the chief or
Can I
your
do
IT
apply?
guy or whoever. Thank you.
Alrighty, well, that was an echoing Judge McNally. Good morning once again, everybody. TCF Live. I'll keep an eye on that court. Hopefully, they don't have to go back to the jail anytime soon. Let's go down to Florida and do our almost daily check-in with Judge Mercer.
You're accused of one count of DUI with damage to property and one count of refusal to submit to DUI testing. I read the complaint this morning. I had the probable cause question. I sent that to the attorneys. Mr. McDaniel, are you wishing to raise that issue?
I'm not, Your Honor.
Okay. So for first appearance purposes only, you're willing to stipulate probable cause?
Yes, Your Honor.
Thank you. So the reason Mr. McDaniel would do that is even though there appears to be deficiencies in the complaint, they may be things they can be fixed, probably can. They never say that you were the driver, but there were two officers involved and only one of them did a complaint. So it looks like the other one might have to supplement the complaint. But if I find probable cause, I can go ahead and address your bond or your release status, Ms. Froines. So we'll find there's a stipulation of probable cause. Criminal history is not bad. A couple of things on there, but nothing that is extremely concerning. No prior DUIs. Mr. McDaniel, anything else I need to know about for bond purposes or conditional release purposes?
Just that she's, works locally, Your Honor, as a CNA and strong ties to the community.
Thank you. Mr. Mitchell.
We'll leave it up to the court on if she's a conditional release candidate, but no matter what, we just want her conditions of no alcohol possession or consumption.
Ms. Froines, I'm gonna let you pick between a bond and a conditional release because of your history. Your bond's $2,500 on each count. There are two counts. So that would be a total bond of $5,000 cash or surety, the DUI with damage and the refusal to submit. Or I'm going to offer you a conditional release because your criminal history is so good. It's not great, but it's certainly not horrible.
Yes, sir.
The conditional release or the bond would have a condition not to possess or consume alcohol.
Yes, sir.
And you would also be given notice for your court date, which would be
June 1st at 9 a.m. Ma'am, do you have any questions about the conditional release versus bond?
I don't have to have any kind of money to be conditionally released?
That's right. There's a monthly fee, but it's not due until a later date. It's
Yes,
$30 per month on conditional
Yes,
release.
sir.
It's usually
Yes,
cheaper than
sir.
a bond.
Yes, sir. Okay, that's what I'd like to do. I'd like to be conditionally released, please,
All
sir.
right. So let me tell you what's going to happen next, ma'am, is they're going to let you use the phone. They're
Yes,
going to let
sir.
you set up transportation if you wish. Then they're going to let you get dressed in your regular clothes. They're going to bring you to the courthouse because
Yes,
that's
sir.
where the conditional release office is at. You'll meet with a conditional release officer. They'll go over everything with you. They'll give you a
Yes,
chance
sir.
to ask questions. Then you'll be free to leave. If you call
Yes,
friends
sir.
or family, you can tell them you can be picked up at the courthouse in probably 30 to 45 minutes. And
Yes,
you also
sir.
have a condition not to drive a motor vehicle unless you have a valid license.
Yes,
So your
sir.
license with DUIs, a lot of times it's unclear right now. So you need to check that out and find out for sure before you drive whether or not you have a license temporarily or not.
Yes,
It's a
sir.
refusal. So
Because I do
it's
need a
alleged to be a
license.
refusal. So they most likely DHS&V will start the suspension process. Ma'am, whether it started now or not, already you need to talk to Mr. Goodson when you get here about that. He can
Yes,
ask you
sir.
some questions about that. Do you have any
Yes,
questions
sir.
for me?
I'm hoping that I can get some sort of work license because I do home health CNA. I'm a self-employed home health CNA and
Yes, no fair. on that.
so that's basically, I've talked to Mr. Goodson, I guess, about that.
Yeah, he's very knowledgeable about that. He knows much more about that than I do. Okay.
Yes, sir. Thank you, sir.
Thank you, ma'am. Thank you,
Have
ma'am.
a good day.
You too. We have Foster Myers next. Mr. Myers, good morning, Mr. Myers. You're here for first appearance accused of one count of criminal mischief. The officer uses a felony. Well, let me back up. On Ms. Froines, we need to let the officer know the error anyway, even though Mr. McDaniel stipulated probable cause, please.
Yes.
Mr. Myers, in your case, the officer uses a felony statute, but he says misdemeanor in the charge section. So it appears that he intended to charge you with a misdemeanor, just used the wrong statute. I'm going to ask Mr. Mitchell to let the officer know about that. Because I don't see a prior criminal mischief on your history, and he doesn't say that you had one. So your criminal mischief can be a felony if you have a prior. So as far as I'm concerned, right now you're accused of one count of criminal mischief as a misdemeanor and one count of petty theft for bond purposes, for first appearance purposes. There is probable cause. I'm going to appoint the public defender's officer to represent you. You also have a child support issue, which we'll talk about in just a minute. And I'm going to ask that you listen to Mr. McDaniel.
Your Honor, I spoke to Mr. Myers. He's going to plead no contest to the charges as listed. The understanding he'll be sentenced to 60 days in the county jail, restitution not to exceed $200. He has signed his plea form waiving his right to jury trial and call witnesses. He have 1 day jail credit. That resolved this case today.
Thank you. Mr. Mitchell, is that agreeable with the state?
It is, Your Honor.
Mr. Myers, did you hear that agreement?
Yes, sir. I have something to say.
Okay.
Now, I took this I agree with the 60 days because he said that if I don't agree with it later on, they're gonna charge this up to a felony.
The complaint, as the officer uses a felony statute, criminal mischief is only a felony if you have a prior.
Yeah,
you would know better than any of us if you have a prior. I see a prior that was dismissed. If you have a prior conviction, let me clarify. So if you have a prior conviction, your second one can be a felony. There's one on there.
I saw.
Mr. McDaniel saw a prior conviction.
I saw a prior conviction, but
Okay, so I just looked at the criminal history. I didn't look at CCIS, which is a different system. So you know if you got a felony criminal mischief or not. If you do, the state might take it to a felony, but the officer never says in the body of the complaint you have a prior. He doesn't say that. That's why I think he just was in a hurry or something. But whether you take the offer or not, the case will be over today if you do, but it's entirely up to you.
I'll take it.
All right. I'm going to accept your plea of no contest. Mr. Mitchell, I think I already asked you. It's agreeable with the state.
Yes. And it is agreeable with the state.
It's a plea of no contest to second degree misdemeanor criminal mischief as well as petty theft. I'm going to adjudicate you guilty of those offenses. Mr. Meyer, sentence you to 60 days on each case concurrent. 370 court costs and fines only in count one. Restitution will be stipulated to in an amount as long as it's not in excess of $200, which is what the complaint alleges. It's less than that. Mr. Myers, you do have that child support matter with a $5,000 purge on it, but you'll see a hearing officer on that within the next couple of days. Maybe get that worked out if you can. Within 24 hours, so you'll see today or tomorrow, you'll have a hearing on that.
All right.
All right. Have a good day, sir.
What you mean?
We have Brandon Calhoun. Mr. Calhoun, good morning. Mr. Calhoun, you've got a couple of issues. You have an out-of-county warrant out of Leon County in a felony case that has no bond on it. And then in Jackson County, you're accused of one count of obstruction by disguise and one count of driving while license suspended or revoked. I'm appointing the public defender's officer to represent you. I'm telling you there is probable cause in the complaint, and I'm going to ask that you listen to your attorney, Mr. McDaniel.
All right. Your Honor, Mr. Calhoun's going to plead no contest to the charge as listed. Understanding he'll be sentenced to 60 days in the county jail, 1 day jail credit. He's waived his right to jury trial and call witnesses, and this resolved this case today.
Was the fine, what's the fine court cost for that?
$400.
Yes,
Thank you. Mr. Mitchell, is that all agreeable with the state?
it is, Your Honor. How many days credit does he have?
One.
One, okay.
Mr. Calhoun, any questions about that agreement?
No, sir.
Sir, is that the plea you would like to enter to resolve these charges?
Yes.
I want to try to protect you from in Leon County if we can, because we normally do that. Is your Leon County a VOP?
Yes.
So, Mr. McDaniel, are you asking for that standard language that you'd like to request?
Yes, Your Honor.
So we're going to put a clause in the sentence that says that what's happening today cannot be used against you in a VOP proceeding. If they want to use the incident, they can do that. They can always do that, but they're not going to be able to use what happens today. If they want to use what happened today, I will let you withdraw what we're doing today. The reason we do that is to go ahead and try to get our cases resolved. Otherwise, no one would ever plead that's on probation because it's going to hurt them. So they still may use the actual date of the incident and try to use that to violate your probation if you're on probation at that time, but they can't use what's happening today in court, or I will let you withdraw this plea, Mr. Calhoun. When you get this sentence down to 10 days or somewhere in that neighborhood, they're going to go ahead and notify Leon County. Do you still want him? If Leon County says yes, they're going to say, y'all can go ahead and come and get him. So you may actually do the last week or so of this sentence in another jail, but that'll be the jail's decision to make sure that you serve the sentence, even though it may not be here. Mr. Calhoun, there's no probation involved in this case. You finish this case, you'll put this all behind you here. Any questions, sir?
No, sir.
Wish you the best, Mr. Calhoun.
Thank you.
We have Chad Gates next. Mr. Gates, good morning. Mr. Gates, you're here for first appearance accused of one count of principal to trafficking in methamphetamine, one count of principal to possession of cannabis with intent to distribute.
He's the principal in this situation for all.
Yeah, I'm just thinking through that. Principal to possession. Interesting. One count of principal to introduction of contraband. So there's probable cause for the charges. That Mr. McDaniel, this is another one. Mr. Mitchell, if you notify the officer.
Yeah, I'll let him know.
Contraband in the prison system, the type of substance determines the degree of the crime. If it's food or clothing, it's a third-degree felony. Almost anything else is a second-degree felony. So the body of the warrant says marijuana, or meth, one or the other. But the statute they refer to as the food or clothing statute, the third-degree felony. So he's actually, the warrant's a little confusing. They'll get it fixed hopefully when they file the information or if they file the information. So Mr. Gates, you've got 3 felony charges regardless. I think you're entitled to a bond. Mr. Mitchell also has an announcement that he notified Mr. McDaniel and I of this morning by text. Is that right, Mr. Mitchell?
Yes, Your Honor. Give me just a second. I've seen if Mr. Gill can work on getting in touch with the officer to amend the complaint right quick. Yes, Your Honor, the state has filed a Nevia motion in this present case, given the fact that he is a principal to a trafficking offense and a controlled substance, which was suspected to be methamphetamine, almost 90 grams of it. We are requesting the court to hear the Nevia motion today, and if we want to go forward on it today.
I don't know if he make a bond, so I don't know if it matters.
Okay, so first of all, I don't know that the complaint has an error. The warrant does have an error.
Warrant, yes.
Okay. So Mr. Gates, I'm gonna go ahead and set you a bond. If you try to post bond, or if you desire to post bond and get the ability to post bond, that's when Judge Garcia most likely would have a hearing to determine the sources of those bonds. There's usually pretty short hearings. Somebody comes forward and says, I want to post bond for him. Here's where the money's coming from. It's not the result of illegal drug proceeds. It's usually a pretty short hearing. So your bond on the trafficking is going to be $50,000. Your bond on the other two charges will be $5,000 each. Your total bond today, Mr. Gates, is $60,000. That's cash or surety. You've got a condition of random urinalysis as part of the bond. There is a temporary hold placed on you for the Nevia motion that's been filed to determine the source of any bond proceeds. So if you do desire to post bond, your family would contact the public defender's office immediately, or your lawyer's office if you hire an attorney, and they would schedule that hearing. Do you have any questions, sir?
No, sir.
Your Honor,
Yes, sir.
we would also request a condition that he have no contact with the co-defendants in this case.
What is the relationship, the legal relationship?
One of them is his mother, the other is his stepmother. I think they're both in custody of the jail right now.
So, Corporal, neither of them have posted bond?
No, they're still here. They're still here.
Okay, so let's just clarify the jail will keep them apart, obviously, because they're male and female. The jail will keep them apart regardless, right, Corporal?
Correct. Yes.
So in the event they multiple people post bond, are you really want me to keep him away from his mother?
Given the fact that their cases are so entwined and entangled, we would still request yes.
Mr. McDaniel.
Your Honor, I would just, argue that it's his mother and his stepmother. I think you got to have some kind of family members to talk to about stuff. And if there's some kind of conspiracy going on, then the state can charge them with it or something. But I mean, no contact with your mom and stepmom seems kind of.
Yeah, I think that's a little overbroad. What I'm going to do is deny that request at this time. Now, Mr. Mitchell, if someone posts bond and you want to file a written motion at that time,
okay.
The only way it would become relevant is if more than one of them post bond, and they've been there for months. This incident was happening sometime in the fall and haven't posted bond now, so it's a good chance they're not going to be able to. But in the event the state wants to file a written motion for myself or Judge Garcia to hear that, certainly we'll consider it. But given that I usually don't prohibit family members or husband and wife, sometimes even boyfriend and girlfriend from having contact, just friends I will. But family's a little different for reasons Mr. McDaniel has stated. So I'm going to deny that request now, but that may come back up later. Anything else, Mr. Mitchell?
You said random UAs?
I did.
No, that's it, Your Honor.
All right, Mr. Gates, any questions?
No, sir.
All right, sir, wish you the best.
Yes, sir. Thank you. Christopher.
We have Christopher Wright. Mr. Wright, good morning. Mr. Wright, you're here for two issues. You have a failure to appear warrant out of Gulf County. That's a possession, drug paraphernalia, and possession of meth charge. They have as no bond. In Jackson County, you're accused of one count of failure to appear in case 26-62 CT. The charge is leaving the scene of an accident without giving the required information. In the Jackson County case, I'm telling you there's probable cause. I'm appointing the public defender's office to represent you, and I'm going to ask that you listen to Mr. McDaniel.
Your Honor, I spoke to Mr. Wright. We're going to plead no contest to the charge as listed. You understand he'll be sentenced to 60 days in jail, 8 days jail credit, $408 fine, and this will resolve this case. Stays with his right to jury trial and call witnesses.
Thank you. Mr. Mitchell, is that all okay with the state?
Yes, Your Honor. Yeah, 8 days credit. Okay, yeah, that is agreeable with the state.
Mr. Wright, did you hear that agreement?
Yeah, I was in the county jail in Bay County since March the 12th. Is that since March?
No, since you pled out.
Since the other one? Okay. All right.
Yeah, the time, I know that you had a local charge there. So the time that you're there for them, they give you credit for, but you get credit for the time you finish, they release you. And if it takes 8 days for us to pick you up, you get credit for that. So that's what you get credit for, not the time you're sitting there on their charge. Does that make sense?
Okay. Yeah.
Is this the plea you would like to enter, sir?
Yeah.
Mr. Wright, I'm accepting your plea of no contest to this charge of leaving the scene of an accident. I'm going to adjudicate you guilty, sentence you to 60 days in jail, 8 days credit, $408 court costs and fines. And Mr. Wright, there's no probation involved in this sentence. And similar to the other case that you heard me do, when you get down to about 10 days, our jail will go ahead and notify Gulf County and see if they still want you. And if they do, to go ahead and pick you up. So you may actually finish this sentence while in their jail. Mr. Wright, do you have any questions?
Yeah.
Wish you the best. Madam Clerk. Corporal, apparently I didn't give Mr. Gates, court date. Please give him, please give him a notice for June 1st.
Second.
June 2nd. Mr. Gates, Corporal, if you give him a notice for June 2nd at 8:30, please.
Yeah, we got it.
Thank you. Decarius Smith, Mr. Smith, good morning. Mr. Smith, you got a violation. Good morning. You've got a violation of probation warrant. I've got a copy in front of me. It looks like a no bond warrant by Judge Garcia. What I'm going to do is go ahead and arraign you this morning. I want to get you a lawyer appointed. So if you want an attorney appointed to represent you, that is, we'll get a lawyer appointed. Do you want one appointed to represent you, sir?
Yes, sir.
Mr. Smith, I'm going to appoint the Public Defender's Office of the 14th Circuit represent you. Listen to Mr. McDaniel, please.
Your Honor, we interplead not guilty. As I said, this in the June 16th pretrial docket, and then I'll let Mr. Blunt know that he's over here and see him there.
Thank you, Mr. Mitchell. Anything?
No, Your Honor.
So, Mr. Smith, someone will see you at your court date or before. Do you have any questions, sir?
No, sir.
Have a good day, sir.
You too.
Thank you.
He was already on there for a free trial for 25227.
And last, we have Thais Pender. Mr. Pender, you have a.
Yeah.
I'm sorry, Ms. Pender. You have a.
Walton County hold.
You have a Walton County hold with no bond, and it looks like your bond has been revoked in Jackson County.
She's got a hearing May
So-
19th in that case. That's already been resolved. It's not resolved, but it's Walton County as a whole.
All right, Ms. Pender, any questions?
That's it.
Have a good day, ma'am. Mr. McDaniel, that's everything I had on my list. Anything else I may have missed?
Nothing else. Maybe just one issue off the record or off the.
Okay.
All right, they're wrapping up there with Wade Mercer. Good morning once again, everybody. TCF Live on a Tuesday. Hopefully it's not a second Monday for at least the majority of you. Glad to have you all here with me today. Let's go to Texas. Judge West, say good morning to her.
Good morning, sir. You Darian Adams. This is 23 DCCR 0492 and 0493.
TRP announcement.
On both cases, correct?
Yes, sir.
What's the announcement?
Your Honor, they've made an offer, but we're gonna need a hearing on this. We can't come to them.
Okay, so did we already go through the motion?
We did,
Did we start going through it and then stop? Because I didn't make any notations of pleads of true or not true. I don't think.
didn't make any on this one either. What we did was I was read through to all the violations except the new allegations was for the misdemeanors. And you said, no, we gotta do them all. So we stopped. There's 2 misdemeanors there. I think one's a shooting.
Okay, I mean, and I wouldn't have said, I mean, I guess as far as an agreement goes.
We will go on what, but did not.
He did plead true to counts 3, 4, 5, 6, and 8. It was reset for an update. So it's, you know,
Something happened and we stopped because I didn't make the notations and we didn't get it updated. So let's start back from scratch. We'll go through the motion, get pleads of true or not true, and then we'll reset it for a hearing. No, ma'am, I'll take care of it. Oh, there's 2. The second one, please. Okay, so Mr. Adams, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down. And will your client waive the formal reading of the motion in each case?
Well.
So, Mr. Adams, in cause number 23, DCCR 0492, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 26th, 2023 for the 3rd degree felony offense of deadly conduct, discharging a firearm. And that was a 5-year deferred probation. Is that correct? And then in cause number 23, DCCR 0493, I also have a motion to revoke your unadjudicated probation. This also shows you were placed on probation September 26th of 2023 for deadly conduct, and that was also a 5-year deferred probation. Is that correct? Both of these cases allege that you violated your probation. Count one in each case alleges that you committed the offense of fleeing a police officer December 6th of 2025. Is that true or not true? Count two in each case alleges that you committed the offense of unlawful carrying a weapon December 6th of 2025. And is that true or not true?
Not true.
Count three in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and that on December 6th of 2025, the arresting officer stated that the vehicle operated by you and occupied by two passengers emitted the distinctive smell of burnt marijuana. Is that true or not true?
Not true.
Count four alleges that you failed to immediately report your arrest to the probation department. Is that true or not true?
That's true.
Count five alleges that you failed to provide verification of performing the community service hours as ordered in each case. Is that true or not true?
Yes, not true.
Okay. Count six alleges that you were at a location other than your residence at approximately 11:23 p.m. December 6th of 2025. And is that true or not true?
True.
Count seven in each case alleges that you were in possession of a firearm by having three pistols located on the back driver's side seat concealed under a black jacket in the vehicle that you were driving. Is that true or not true? And count eight alleges that you're behind in your court assessed fees as of December 8th of 2025. In cause number 0493 in the amount of $540. And in cause number 0492 in the amount of $2,942. And is that true or not true? All right. Did you enter your pleas of true in each case to counts 4, 6, and 8 freely and voluntarily? I'm sorry. And did you plead true to those counts because they're actually true? All right, then I'm going to find those counts true, find that you entered your pleas freely and voluntarily, find sufficient evidence in each case to revoke your probations and find you guilty. But I am going to reset this case for a hearing. Do you anticipate, I guess, a little bit of time on this one with witnesses?
I think so, Judge.
Like,
There's nothing had fences.
I'm sorry.
An hour.
Okay. All right. So we'll get it set for a hearing. I'll get an updated pre-sentence report and okay, we'll do it on a different day than a docket day then. All right, you can go back with the bailiff.
Did you want to? Yes, sir.
Yeah.
Big excuse tonight.
Yes, thank you.
Mr. Adams.
Notice. Simply today. See, is Mr. Cashin and Mr. Johns and Larry Fitzgerald Williams.
Good morning, Ryan.
Good morning.
I haven't heard from this just. There are a couple of housekeeping matters that we needed.
All right, let's wait for the defendant.
Yes.
Good morning, you're Larry Fitzgerald Williams. And this is cause number 25 DCCR 0985 and 24 DCCR 1790. Mr. Williams is charged with capital murder as well as aggravated assault causing serious bodily injury. And what is the announcement, Mr. Cashin?
We need to take care of some housekeeping matters because the last time we were here, you had ordered the state to provide us with written notice
whether they're gonna seek the death penalty. And yesterday afternoon, when I left my office, I had gotten nothing from the state as to whether or not they're gonna seek the death penalty. And I would like that information as soon as possible, in accordance with the order that you have.
Mr. Smith?
State's not seeking death penalty, Judge.
Okay, if you'll get that in writing to Mr. Cashin, so he has it for his file. That way that gives him the opportunity to know how to move forward. I'd like to get this case, if it's going to be a trial, tried before the end of the year.
Yes.
And so I want to,
Agree.
And there are some other issues, Your Honor. Back when we first came to court, I had filed a motion to quash the indictment because the indictment, from what I understood, was incorrect because it was under a wrong provision and it was for retaliation against the judge. And they have not corrected that in that indictment.
just let me pull that.
Yes, ma'am.
So I think we discussed this, and it's only the heading, which is not substantive. Obviously, the substantive part of the indictment is what the actual charge is, which is the retaliation
Yes.
against Mr. Lewis. It's the indictment itself is not going to be quashed because of what's ultimately a typographical error in the top.
Okay.
I do think it's clean, or for the record, if you want to make an oral amendment, I think that's something we can do today.
Okay. Right from the state.
I think it needs to be correct as well. And it's not 18. I can't remember which one it is, but I'm gonna look. I know we had this conversation.
Yes, we have.
Do you remember which one it is by
In the
chance?
very beginning, well, I left that file in my office.
That's all right. I can figure it out. Let's see, 19. Go to. A.
T. I mean, that is correct.
That is correct.
1903.
1903, 18 is correct.
It is.
I can live-
There was something that I do recall us having a conversation about, but
Well, it says murder for retaliation, judge justice. I mean,
oh, the
we
judge
can line
justice
through
needs
that.
to be interlineated, but the
Right,
section
that's-
number is actually
Okay,
correct.
that's
Yes.
what I'm,
That's the, okay.
that need to be delineated.
Any make an oral motion to
We would
do
make
that?
an oral motion to strike that from the.
Okay, and
Hold on, any objection to that?
no, Your Honor.
All right, give me just a second to get it done before I move on. It doesn't want to give me that option yet. Okay. That's weird. And we need to, did you, make a note on a ticket? For some reason, the one thing that I need, which is the interlineation thing, is not letting me do it, and it has in the past. Okay, so I'm just gonna print it. Yes, and we'll do it that way. Okay, what else?
We recently got an email from Mr. Smith about some discovery. And I bought a 1 kilobyte, or 1 terabyte drive to be copied, the information that he's referring to.
Okay,
And so I would like that. Then I have a motion to change venue right here, but I need to get Mr. Williams to sign his affidavit, and it will be filed this morning.
okay, so with regard to discovery, y'all can take care of that.
Yes, ma'am.
I don't need to get involved in that. And And then, if something is filed, with regard to a change of venue, I'll get that set for a
Yes.
hearing within the next few weeks.
Yes.
Obviously, that's something we'll need to get taken care of so everybody can plan ahead
Yes, ma'am.
on what we're doing. So once it's filed, I'll
It'll be,
give everybody an opportunity to get ready and we'll get something set, I would say within 2 or 3 weeks.
Thank you, ma'am.
Okay, anything else?
That's it for now.
Okay. All right, if if you need him to sign that in front of
Notary.
if you can step over here in front of the clerk, she'll take care of that.
Thank you. Thank you, Judge.
Thank y'all. She's gonna go get her
Notary.
notary.
All right, friends, we'll come back to Judge West after she's lined up another contestant, but let's change it up. Let's go up to Newaygo County, Michigan. This is Judge Springstead.
Yesterday to 24 months, the Michigan Department of Corrections. Was the pre-sentence investigation report time made available to the parties?
Was, Your Honor. Your Honor, I just received a supplement yesterday, and was able to get it to my client yesterday, but we haven't reviewed it yet. It has to do with restitution, mostly.
Mr. Walburn?
It's possible, Your Honor. I don't dispute we gave that to her. I'm not sure, Your Honor, when we're sending out the supplements.
All right. Do you need to go over that with Mr. Cartwright?
I know next week's a trial week, so I guess 2 weeks.
June 16th at 11 o'clock. You agree with that, Mr. Cartwright? You want more time to talk with Ms. Frisbee about the restitution issue?
Yes, sir.
All right. You understand that you're not going to get credit against this case from now until that next time because you've already been sentenced in that other case. So it costs you a couple weeks for the credit. Okay, all right.
Yeah, I think victims have arrived on this case. I prefer not to make them come back. Is there any way the court would at least consider that, allow them to make a statement if they wish, or the whole thing can be pushed off?
That's fine with me.
I don't know who's here. I'm just getting emails from staff. I know I have 5 people that return victims' rights on this.
All right. Is there anybody here that was a victim with Mr. Cartwright that wants to address the court today? All right, come on, man. Let's start out with your name.
Oh, I'm Valerie Richard, and I'm the treasurer of HOA, Heslake Hills HOA.
Okay.
And Mark Tristan broke into our mailboxes, and then the post office deemed them unsecure. So we had to buy a new post box cluster, and that was $2,400 and 63 cents or something. And because the old cluster was put in over 25 years ago, the post office made us come to today's standards. Before we were grandfathered in, it was right by the road. And so to come to post office standards, we had to move the box back and pour a slab and put in 2 bollards to prevent anybody from driving up to the mailbox. And that bill was $1,565. And the grand total was $4,027.54. And that is a big bite out of our budget because we only have 11 households. We pay $600 a year each household, so $6,600 to work with to pay for our dumpster, our electric, the street lights and the gate, and and the plowing, because we're a private road. That is pretty much covers it. We have to do our own maintenance on our road because it's a private road. We have to pay for our plowing on the road because it's a private road. We need some repairs on the road, and pretty much that money was savings for a section of our road. I got an estimate to do just one section of our road, and we didn't have enough money, so we couldn't do it. So we were saving, and then when Tristan here broke into our box, that pretty wiped out our road thing. And I came here to court because I didn't want this to be brushed under the rug. I'd really like restitution for what he's caused, not to mention the duress. Every member has to go to the post office to pick up their mail every day or 3 times a week or whatever they can schedule. For the young families, that's been really bad because they work day shift and they go to work before the post office is open. And by the time they get off work and get to the post office, it's closed. So they're in even worse condition than me. Like me, I'm a retiree, so I'm more free on my schedule, but it's been very bad. And this has been going on since before Christmas. And Christmas, around Christmas time and right after was the worst because the post office is quite busy. So you could end up waiting a half an hour in the post office in line for your turn to receive your mail. So, I mean, it's just wrong that he's caused us all this grief. And I want the judge, I want you to tell him he has to pay and put a time limit on it because we need those funds to operate our HOA. And that's what I wanted to say today.
So in the sentencing report, they had down that the Hess Lake Hills Association is requesting restitution for $5,102.54.
That's not correct.
Okay, so you're sure that the complete number is 4,000?
$4,027.54.
Okay, all right. All right.
The cluster was 2462.54, and the cement job was 1565.
Okay, we've got that. So the court is going to order that he pay restitution. But the problem is he's going to prison. He's going to go to prison for a couple of years. They do make a little bit of money in prison, but I mean like 10 cents an hour, 15 cents an hour. So that you may get a little bit of restitution over the next couple of years, but not very much. Then when he gets out, then we can start some collection processes in earnest. But realistically, unless he's got some family members or somebody that's willing to step up for him, it's going to be probably 4 years before you see this money back.
Well, I just didn't want to get swept under the carpet because it's very important for our little association. We have expenses and this was really bad. This was not counted for. And
I understand that. So another possibility that you may have looked at is, if you have some common area insurance, maybe the insurance could cover this.
we do not. There's no common area. In fact, the address that we use is my address because I'm the treasurer, so the bills come to my personal address.
All right. Well, thank you for coming today and sharing how this has impacted you.
Okay.
Thank you, ma'am.
Do I get anything from the court that says that he's still ordered so that if he doesn't pay?
Yeah, you can get a judgment of sentence that indicates what he's ordered to pay. The payments will be tracked through my court.
Okay.
And as soon as he gets out of prison, we'll bring him in. He'll let us know where he's working and what his plan to repay is, and I'll get as much money per month as I can out of him.
Okay.
But It's gonna be a while.
Yes, I
Okay.
understand,
All right,
but
thank you.
I felt if I didn't come, nothing might get done.
All right, thank you for coming, ma'am.
Okay, thank you.
Is there anybody else on the Cartwright case that wants to address the court?
We got to take it out.
Okay. All right, so I guess I gave you the new date already, right?
Yes, Your Honor.
Okay, all right, that's all today.
Okie dokie, friends. About halfway through our Tuesday show today already. Once again, as I pointed out yesterday, time flies. Or as my father used to say, time is fun when you're having flies. Not exactly sure what he meant by that. Let's go back to Texas. Judge Stevens this time.
Remember your friends if you do that. Yeah, I'll say you make like for now you saw. I understand this. Go ahead. Okay. I'm looking at 3 cases. 25 CR 367, which is operating a motor vehicle while intoxicated, third or more. There's all of these are that. But this one was indicted over a year ago, and there's been no. We had initial docket. No. No. Don't see any resettings at all. This is a brand new resetting, but it was over a year ago. Then July of last year, a second DWI rolls around. Third. And then here, April 1st, this year, last month, a third DWI rolls around. Why has it taken so long for him to show up in court? I'm asking you, have you been traveling around or what?
Oh, no, sir.
Well, you picked up 3 separate DWIs on different occasions. Do you know that? Do you know that, or
Yes,
you're not aware of this?
Yes, sir.
Okay, you've been arrested 3 times, and you were indicted. One of these is September of 23. We're going on 3 years. Gosh, and nothing had been done. Where do you live?
105, Highway 105.
Yeah, there it is. You were I have these addresses as Windmere.
Yes, Windermere, Highway. Paige.
But that's where you live.
Yes, sir.
You didn't know you had a case pending 3 years for 3 years?
Nobody ever told me.
No, somebody's supposed to tell. Weren't you arrested?
Yeah, I got
3 different times.
And
You think they're gonna come to you? You didn't think that maybe you ought to take the offensive on? You, according to this indictment, you committed 1 third-degree felony, then you picked up another third-degree felony, and then you picked up a third one. You see anything wrong? Do you?
Yes, sir.
And we're going to take care of things here because this is serious. And on the last one that was just indicted, not only do you have a third-degree felony, but they have added 2 prior convictions, burglaries back in 2017. So this third-degree felony, if you're found guilty of this, it becomes punished as a second-degree felony. If this is correct, you're looking at up to 20 years. So you're looking at a total of 40 years in prison.
More than that.
Well, no, on the first one, a prior conviction is alleged, but not on the second one. So you're looking at in 367, up to 20 years in prison. On 501, up to 20 years, and then up to 10 years in 840, 50 years in prison. You want to look at me like like I can't believe it's not butter. You know better than anybody else what kind of trouble you're in. This is really disturbing. Did you drive up here?
Yes, sir.
Who? Why not?
So
Why not? Did you walk up here? You walked up to the, sir?
from where?
How'd you get to work?
I had my drive.
Where's your car? Where's your vehicles? Why not? Why don't you have a vehicle? Speak up, so.
I don't have a vehicle.
When did you, well, you had vehicles here. Where'd they all
I haven't had
go?
a vehicle in probably about 2 years. Or a year and a half, so.
No. The day before January 1st of 2025, which is a year and a half ago, you were arrested.
Right.
So a year and a half ago, you had a vehicle.
That's what I said. Said I hadn't had a year.
No, you said
A
2 years.
vehicle in about a year and a half.
It's for misdemeanor.
I'm sorry. Go ahead, Langston. What are you gonna?
No, I was just asking to put him
on all of it. This is a mess.
Right. I was going to actually put him on the announcement from the initial, and that way I can go through his discovery with him, meet with him, and then we can come up with a plan on trying to resolve all of this. But I did get all of his discovery, and I have all that downloaded from the DA's office.
I have one on that.
What are his bonds on each of these, please?
On 0367, it's $35,000. On 0840, it's $35,000. And on 0501, it is $15,000.
The more you commit offenses, the less the bonds are. Go figure. I mean, this is a Twilight Zone episode. What was the last one again?
15,000.
Woefully low. But you got more problems. You got a warrant out for your arrest right now for resisting arrest. You're going to be taken into custody. That's the first thing. The bond in 26501, which is the third pending felony that you've committed here after the September 21st, 2024 incident and after the September 23rd, 2023 DWI third, then on or about December 31st, 2024, you committed a third one here after those other two, and then that bond this court finds is the first two bonds were 35,000 and 35,000, and then thereafter you commit a third offense of a third-degree felony, which is enhanced because of two prior burglary convictions of habitations in 2017. So this is now a second-degree felony. And then for some reason, the magistrate's bond reduced, so which defies any logic. So we're going to fix that. That $15,000 bond is revoked, and that's a it doubles $70,000 bond. And then you're going to be arrested here for this capias and taken into custody for this misdemeanor that's pending. You cannot operate a motor vehicle unless right now, until this court allows you to, because this is a disturbing, I've never seen this. 3 successive third-degree felonies over and over, which means you don't get it. And the rules don't apply to you. But again, you're talking about 50 years imprisonment on all of these. And that's going to be treated seriously. You can't operate a motor vehicle until further orders. Also, are you an alcoholic? Do you have an alcohol problem?
So I believe I do.
You believe you do. All right. Okay.
I do have that.
Well, we're going to work on that too. What the state suggests on just for testing on him, so that because I don't want.
Well, since one is for alcohol, one is for marijuana, we probably have to have the scram and a patch, drug patch.
Make sure we cover all bases.
You're just free falling right now, sir, as you know. And you have to fix this, since you can't fix it yourself. So you will be ordered to have a drug patch, and you will be ordered to have a scram device, which tests you for alcohol, but you were unable to operate a motor vehicle. You are right now free falling, and you are not safe operating a 4,000-pound missile around town. You just get arrested over and over again. We're lucky someone hadn't been harmed or, at worst, killed by your reckless behavior. Do you understand?
Yes, sir. I do.
You'll be taken into custody here immediately.
You're an approach.
And no, hold on.
Sorry, I thought you were about to.
Yeah, I am, but you're going to be next. Langston, what do you have to say? Anything else?
I didn't know about the resistant. I just want to put on the announcement.
We're going to make a copy for you.
Okay, that'll work.
And you want to put it on the announcement docket, right?
Yes.
Okay, it'll be placed on announcement. Okay, what else on this? You'll get a resetting too. And we'll get you up here if you're in jail, but you've got my attention, and the 250,000 people of this county are going to be safe with you not being around town, driving a vehicle improperly, recklessly, and without regard to other people, much less yourself. That is all. You're in custody. Yes, sir.
Judge, I do have one on the docket. And
is it Andrew?
It is.
What are you going to do?
Langston.
I'm having jury wait in drug court. So
what are you going to do?
Well, that one, the reason we're here is for review.
All right, we'll keep an eye on Judge Stevens' court. Let's head a little bit east, though. We haven't been here in a week or two. Let's go to Louisiana and the Parole Board.
And Corey Crockett there.
Yes, sir. Good morning.
Good morning, Mr. Crockett. What is your DOC number?
It's 35 356961.
Okay, 356961, correct?
Yes, sir. Yes, sir.
Okay, all righty. And your case this morning is going to be handled by Mr. Tillis. But before we do that, I want to make sure that you got a waiver form in front of you talking about the rights. And did you sign that and agree to that? Agree to this
Yes,
hearing?
yes, yes, sir. Yes, sir.
Oh, okay, thank you. Thank you. Mr. Tillis?
Good morning, Mr. Crockett. How are you?
Tillis, I'm blessed, sir.
I'm going to read some violations and you can answer guilty, not guilty, or with a statement. The first violation is number 3. You failed to provide our office with a current address. Our office attempted to locate you at the address of record. Once officers arrived, we were notified by family members that you do not live there at this address. They were uncertain of your location. A warrant was issued on 11/17/25 for absconding. How do you plead? Guilty, not guilty, or with a statement?
I plead with a statement, sir.
Okay, tell us about it.
Okay, I had discharged from Hunts Correctional on September the 10th of 2025, and I was moved with my daughter until I could do better. But it had things going on at that residence that wasn't approved by probation and parole. So through my actions, I moved around it. And when I moved to 2908 Sycamore Street, in which I didn't give up the address, hadn't given up the address. I was trying to get back on my feet, in which I was arrested at the restaurant I worked at Venice Soul Food Kitchen on North Street. That's where I was arrested at, sir.
Okay, so you didn't get in touch with your parole officer? You didn't tell him your address?
No, sir. Due through the rage that I was going through, and at the time I lost all my family members, so that was the only place I had to go to. You know, all of them passed away last year.
Okay, violation number 4. You violated a current protective order. Our office received a call from the Baton Rouge Police Department advising their victims unit had received several calls from the victim. Warrants were issued on 11/17 for violations of protective order, for a violation of protective order. How do you plead?
I plead not guilty to that, sir, with a statement.
Okay, go ahead, tell us about it.
Okay, once I was released from prison, I had no contact with this lady. I don't even know where she stayed, none of this. But in November, one day before Thanksgiving, the officers was called to where I was at the Q-Mart buying bar meat, and the officer had put me in handcuffs. And the guy at the store, who owned the store, asked him what happened. And he stated that I was supposed to be stalking the young lady, Veronica Green, in which I haven't. So he ran the store and he looked at the cameras and he seen that I was nowhere around her. I was at the store at the present time that she gave, the time that the incident was supposed to happen. So he let me go out of the car that day. And she's bipolar, paranoid, schizophrenic by the state of Louisiana. So it's just was a lot of accusations that she made towards me. And also I was at the Christmas parade with my daughter, and a city police officer seen me, called my name and told me, like, you have to be very careful of this young lady. Say, I'm not gonna do you anything. You let me go then. So therefore I don't understand where I got in violations at, you know, because I haven't been around her since July the 7th of 2024.
Okay. You failed to make payments toward your supervision fee. How do you plead?
I plead guilty with a statement on that, sir.
Okay, go ahead. Tell us about it.
Okay, on that situation there, by me moving away from with my daughter and the place that I was going to, I had to come up with money to stay there, and therefore that I was working at Benny's Soul Food when I was arrested. That's where I was arrested at, and I was working to make preparations to give me my own place to stay and to pay towards my parole, supervision fees, and my child support. But I just had only been out since September the 10th, and I got arrested January the 28th of 26. So I just had been out just a few months, and I was really trying to get on my feet.
I see. In Anyone else have any questions?
Let's see. I got a question. In the preliminary hearing summary, it says that they had a photo taken of you across the street from the victim's home. What do you have to say about that?
I had no idea of where the victim stayed, sir. The last time me and the victim was together, we was together on Fry Street. But I went to court from Hunts Correctional in June of 25. And on the paperwork that I have, it says on the street for the address of her. I had no knowledge of where she was. I have not been around her. I don't know why she's making all these false accusations, but I have not been around her. Like I said, if I was to be released from this situation, I would wear a GPS monitor to let y'all know that I don't go nowhere near her. I don't even want no parts of her in my life. You know, I have not been around the lady. I don't know what's the problem with her instead of making these false accusations, sir.
So basically you're saying you don't deny that the picture was across the street from a house, but your statement is that you
I don't know where her house is. That's the thing of it is. I don't know what area she stays in. I have not even had no kind of encounter with her since July of 2024.
Never seen her?
Sir?
Never saw her or anything? You don't know?
I haven't seen her since I got out of prison September the 10th. I haven't seen this lady nowhere in sight. So I don't know why she's making false accusations against me, because there's been 2 occasions where if I was in the wrong, I would have got arrested. From the Q-Mart, one day before Thanksgiving, and at the Christmas parade on Gushon when I had my daughter with me. So if I was in violations, I think I should have been arrested. But the officer went into the Q-Mart on North Street and Foster Drive and looked at the cameras and seen that I was there when he said that he went back to her house and didn't see me nowhere on no camera. So where is her house? I have no idea, sir. And I'm telling you the honest truth.
All right, no more questions. Yep. I'm I'm wanting to believe you, but I have a problem. The more you get in trouble, the more apt you are to not be believable, I guess you might say. You are a 5th offender. You're on parole for 3rd offense, domestic abuse battery is what you're on parole for, and possession of a firearm by a convicted felon. And now you're charged with a pretty serious thing of this domestic or this protective order that you violated, but for sure you didn't notify, and you admit that you did not notify probation parole where you were living. And
well, once I had got out, the first I had gave that address.
Wait a minute.
Yes, sir.
Finish. You've been on parole before, I imagine. Have you not?
Yes, sir.
You know the importance of something as simple as telling them where you live, correct?
Yes, sir.
And you didn't do that. So why should we believe these other things when you didn't abide by the simplest rule that there is?
Well, Mr. Prater, I was going through some dramatic changes. I just had got out September the 10th, and all this here was happening with my daughter and the stuff that was going on in the house. Plus, I lost my whole family. I'm not asking for pity. I'm just asking you to just give me a try. You can put me on GPS monitor or whatever you have to.
Yes, sir. I feel like we did give you a try, but that's all the questions. I just wanted you to know my concerns and what I was concerned about.
I'd like to go into executive session at this time.
Second. Got a motion and a second for an executive session to take care of some procedural matters. Got a motion and a second. There's no objection. At 9:06, we will be going into executive session for just a few minutes, and we'll be right back.
Yes,
and then we'll ask some more questions if we need to, or let you know what our decision is.
Yes, sir.
All right, friends. Well, we will come back after the executive session. In the meantime, let's go back up to Michigan and Judge McNally.
Hi, your name?
Kenneth Johnson.
Okay, it says dismissed in the interest of justice. Do you have a fishing license?
No, I actually gave it up after.
How's that in the interest of justice? You were fishing without a license, right?
Yes. I just don't have money to pay the ticket. I asked.
Call in you should have thought about that before you fished without a license. Right? Don't you think?
It was the first day of the new license. I had forgotten to re-up it.
Hello?
Hi, good morning.
Can I have Ms. Osmaro in here, please? Thank you. Thank you. Say again.
It was the first day it was the first of April. And I didn't renew my license yet, and
So why were you fishing if you hadn't renewed your license?
got too excited about it.
Ms. Osmaro, your name?
Good morning,
I don't mind if they got a license, that's up to you, but he doesn't have a license. Why is this in the interest of justice?
Your Honor, I did state in the interest of justice while I'm speaking to the defendant in the back. He did mention at this point that he was just asking for that he be considered with mercy. He doesn't have anyone to pay any of the tickets or be paying. If you want to take a chance to explain as well, so you see, I guess.
He's either going out, I'm not gonna dismiss this unless he goes out and gets himself a license, period. So you're either gonna plead responsible here today as charged, or you can, I'll give you 2 weeks to go get a license. If he gets a license, I don't have a problem with dismissal, but I'm not gonna just, everybody finds ways, right? I mean, so what is your choice?
License, that's the case.
Do you work?
I did.
Where?
Dollar Dairy.
How much you make there?
About 15 hours.
You have kids?
5.
Adjourn 2 weeks. If the defendant gets licensed, no problem.
Thank you, Your Honor.
If I find a way to get it today, I just got back and showed there.
Well, you just told me that you didn't have the money.
Because I don't.
Go get it now and come back. Go get it now and come back. Go get it now, come back. If that's what you want to do, I'll be glad to dismiss it. If you don't get it today, then I'll be glad to give you 2 weeks to adjourn. It's up to you.
Sorry.
Which is your choice?
I'll make some calls when I leave and I'll go get it today.
Okay, good enough. Come on back. Just try to get back here no later than 11, okay?
Will do, sir. Thank you.
All right, good luck. Dana A. Baker. 25W840758. Thank you.
Good morning, Evan.
Good morning. Your name?
Thank you.
So you were supposed to pay 50 a month starting January 18th. You didn't pay anything until paid $10 on February 19th and 100 on May 12th.
I just paid 100 just now.
I know.
She let me know.
So why didn't you come and talk to us though? I mean, it's hard for me to give people time to pay when they're already 4 months late. You follow me? I'm gonna do it for you, but stop this. That's a bad habit. How much time do you need? I'll be glad to you can set up your own payment plan.
No, $50 a month is good.
Well, do you work, ma'am? Do you work?
Yes,
Where?
at the airport.
How much you make there?
I don't make much.
Well, I don't know what that means. What do you do?
Like I do.
You pay 50 per month, beginning June 1. If you need more time, you call the court. I'll be happy. We can go on Zoom or you can come in here on or before the due date. I'll be glad to give you an extension, okay?
I do, instead of doing 50 a month, can I do 100 every other month? Like I just paid 100 today. So today's date, can I pay another 100, like a month? That makes sense every other month.
I don't care how you do it. You can't pay 50 more by June 1?
I might, but I might not be able to. I'm gonna do it.
Right? Tell you what, then to pay 100 bi-monthly. Then to pay $100 bi-monthly, beginning June the 15th, okay?
Yes, that's fine.
Now, if you don't have the money, it's not a problem. It really isn't, but you gotta call the court and show some respect, all right? And they'll either tell you to come in or you can do it on Zoom if you'd like. I'll be glad to give you an extension. Just don't ignore me, okay? Best of luck to you. Marasco. Richard Joseph Marasco, 267-125-988. Morning, sir. Could I have seated up here Dorian Jones? At the table, please. Sir, your name?
Richard Marasco.
Good morning, sir. You're charged with driving over a sidewalk and then
Yes, sir.
it looks like I can't, hang on one second. I can't quite read this. It looks like he's saying that you didn't change your address.
Oh. Yeah,
So hang on.
Okay.
You have the right to a lawyer. I'll be happy to give you one. Would you like a lawyer? Let me give you a lawyer, okay? I'll give you a lawyer on this, all right?
Okay.
And you can go talk to the lawyer right now, and then you can come back in front of me, all right?
Okay.
Best of luck to you.
Okie dokie, we'll probably check back later, I would think maybe, but let's go back to Louisiana. They are out of executive session.
Okay. Got a motion and a second to go back into regular session. The time is 9:11 in the morning. And there is no objection, so we are hereby back in the regular session. So, Mr. Tillis, I believe it's up to you to either continue questioning or if you're ready to vote.
I have no more questions. Do you have any? I'm ready to vote then. Mr. Crockett, based on the evidence that we have, the violations, my vote is going to be to deny or violations number 3 and 4. I'm sorry, revoke you for violations or 3 and 4. Thank you.
And what are those, sir?
You failed to give an address of your address and you were arrested. They pick you up. Number 4 is violation of current protective order, and you violated a violation of a protective order.
Was sir, I never been to court or any.
Wait, we're voting right now, Mr. Barrow.
I'm going to concur with Mr. Tillis for the same reasons.
Okay, and likewise, I'm going to concur with Mr. Tillis that you be revoked because of violating condition number 3 and violating condition number 4. So as of 9:13 this morning, your parole has been revoked. Thank you and have a good day.
Okie dokie, he's revoked. We might check back in with the board later. We'll see. We got 45 minutes left to go here at TCF Live on this fine Tuesday. Let's head back to Judge West.
(0802). Mr. Clark is charged with indecency with a child by sexual contact. And what is the announcement?
Judge, this was set to this court date for a status. I think Ms. French had ordered the CPS records.
Hold on a second. I need y'all to all hold it down, please. Go ahead.
Ms. French had, through the court, obtained CPS records. We both have copies of those.
Okay, good.
So I think at this point, we're needing to just set this back on the trial.
Okay.
There's already a rejection on.
Has there been any change in what the offer was? It looks like it was back in August of last year. There was a rejection of a 12-year term.
Correct, Judge. And I don't know what Ms. French intends to do, but I do know that she is planning to meet with the complainant soon.
Okay.
And we talked about that today. If there is a change, we would obviously bring that to the court's attention
Sure.
beforehand.
Let's go ahead and get it on a trial day.
Just because it got the nature of the case, I think.
Yeah, for sure. All right, so Mr. Clark, I'll get your case set on the trial docket. If something changes with any negotiation, y'all just let me know as soon as that changes, and we'll get you back in here. Otherwise, we'll see you at the next on the first trial date. Okay. Trying to go back to the bailiff. Thank you.
Okay.
What's happening? Hey, Mr. Gertz. Kimler. Oh, he's in trial. I wonder if, well, did he say anything about, by the time they're getting started? Ryan's on our docket.
I saw that, no, he didn't find anything out. They're having docket time.
Would you shoot him a message to come take care of Spites real quick before he gets going in trial?
check on the way out. Gotcha.
Thank you very much. Appreciate you. Logan Eaglin, Ms. Perazzo.
Logan Eaglin.
Good morning.
I didn't know.
Well, good morning. Are you Logan Eaglin?
Yes, ma'am.
And I really need y'all to, if y'all are talking about a case, don't walk across each other, get closer. I'm having a hard time this morning for some reason. Mr. Eaglin, this is 25 DCCR 0897. You're charged with aggravated assault with a deadly weapon. Your case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, this is a case that the state will dismiss because we're re-indicting as a murder. We found out that the victim died approximately 7 or 8 days after the assault.
Okay.
So it would be not tried as the aggravated assault, but tried as a murder.
When do you anticipate that indictment?
I think it will go tomorrow.
Okay, so obviously if that's gonna happen, it doesn't change a lot of the discovery, I wouldn't think, and so we can go ahead and leave it on the trial docket.
Yes,
Because you've already got everything, it just changes the nature of the offense, correct? All right, so but I guess. I mean, if it's indicted tomorrow. It changes it enough to where if you need some time, you're entitled to that.
Yes, Your Honor, if we could have at least 30 days.
Yeah,
There will be at least an autopsy report and
so
pictures.
potentially some additional things for you to go over. Okay, so what I'm gonna do, Mr. Eaglin, is reset your case to the next trial docket, so that once Ms. Perazzo gets everything, any additional discovery, which it sounds like there's some more information coming because the case is going to be, upgraded to a murder charge instead of the ag assault. We'll give her some time to go over all that, go over all with you. If there's any new offers or plea negotiations, then let me know if something changes before that trial date, we can get it taken care of.
Yes.
Okay, you can go back with the bailiff. Let's see, Mr. Smith, Mr. Wilkerson. Let us know that he is not going to be able to be here today, but that you already let him know. Are you ready on Dalvius Williams? Oh, okay, we're finished with Dalvius. Yes, ma'am. Williams, thank you, sir. Mr. Radford, you have Floyd Toran, the sentencing. Good morning.
Did you get the medical records and things else?
Who'd you send a medal to?
Kelly,
When?
maybe. No, I emailed him. It's 3 or 4 weeks ago.
Did you email him to Mr. Smith as well?
Did you get the medical records? Did you sound better? About 3 or 4 weeks ago. Yes, I think I did. You emailed them.
There was at least another email address. I know that it was which home, so I wonder if it went to the wrong person.
No,
Correct.
what day was it?
I was about, spinal top stuff?
Yeah.
What day?
Can you tell what day he emailed it?
No, I don't think I
This is
sent it
just-
the email. It was about 3 or 4 weeks ago.
Can you look and see what the date was?
From my office.
Oh,
Don't know if it's gonna show one.
All right, well, obviously I'm gonna need a minute to go through all this. He can go back for a few minutes or have a seat.
But they can bring it back at home.
This is discovery stuff. Some of this is. I don't think he wants to hand me all of this.
I gotta look at it. Somebody else should have to look at it.
I don't know what that didn't have anything to do with what I need to look at. I don't
So
know.
right there's some spinal tile and I think there's TDC. Shows that it's one month. That's vision. Shouldn't be driving.
Let's go ahead and get it back out. I'm fine. You can summarize for me as well. That's okay. Nothing. I don't know. I mean, I guess it needs to be in the file. If it's something I've reviewed, it needs to be attached where the PSI is or something, please.
I mean, that's usually what I do. Submit additions to the PSI's email.
It was just with sounds like it wasn't like.
It's all right. You found it?
Yeah.
Okay. Yeah, with my discovery certification.
Okay, you're Floyd Toran. And this is cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Toran was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle also enhanced to a second degree. I've received the pre-sentence report, and the agreement was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just a straight second degree with an open plea to the second, correct?
Yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Toran's mental health, as well as some physical issues, and one letter as well of support. Have you both had an opportunity to review all of that?
Yes, ma'am. Yes, Judge.
Are there any additions or corrections to that pre-sentence report?
Just the things that I submitted, Judge.
Okay, Mr. Radford, you may proceed.
Judge, Mr. Toran has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spindletop MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
What is the status of parole?
No, we're waiting on the way. Okay.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, was the fact that he was incarcerated. I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual and cap this at 20 years. So we would ask for TDC sentence in the high range on this.
So, Mr. Toran, in 2019, You received a 15-year sentence. So you were only not, I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously. So you got out in 2023 and less than 2 years later, you've got 2 more felonies, which add up to your 11th and 12th felony offense. And I understand the issues with PCP. It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you as a grown man have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that. I mean, your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment. I don't know, I just think it's I appreciate your family being here, and I appreciate the support, and I appreciate this letter, but it's all ridiculous when you look at your criminal history and the fact that you're on parole and you commit 2 more offenses and you're still using drugs, and you haven't made, it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794, and this evading was crazy. I mean, you could have killed people. You got used, I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. I mean, it's not like you just kind of sort of evaded. Your behavior is just a danger to everybody here in Jefferson County. So that being said, 25 DCCR 0794, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property, find that prior conviction true, or the prior convictions true in that case, sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. And cause number 25 DCCR 1152, find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. I'm handing you, and they will run concurrently, which means together at the same time. I've handed you the trial court certification that shows these were agreements. I followed. You've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that. You should already understand it. But if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right, you can go back with the bailiff. Yes, sir.
Okie dokie, friends. TCF Live about to enter its final half an hour for today. Let's go back up to Michigan. We haven't been to this guy in a while. Let's check out Judge Wiggins.
Good morning, Your Honor. Jeffrey Rupp appearing on behalf of Mr. Couch, who appears to be present in the courtroom.
Yes, he is. Thank you. Council, we are here for a probable cause conference, but I also see there's a second amended complaint in the file, so we'll need to arraign Mr. Couch on that. Mr. Rupp, were you aware of that amended complaint?
I was, Your Honor.
All right. So, Mr. Couch, I have an amended complaint. It alleges that on or about April 28th, 2026, in the city of Manton and Wexford County, it is alleged in count number 1 that you committed the offense of police officer fleeing 3rd degree under the vehicle code. That is a felony punishable by up to 5 years in prison and or $1,000. And the Secretary of State shall suspend the license for 1 year. In count number 2, it's alleged you committed the offense of malicious destruction of personal property, $1,000 or more, but less than $20,000. That is in regards to a fence. That is a felony punishable by up to 5 years in prison and or a fine of $10,000 or 3 times the value of the property destroyed, assuming the prosecutor can meet certain requirements. In count number 3, it's alleged that you committed the offense of weapons, ammunition, possession by a prohibited person. That is a felony punishable by up to 5 years in prison and or a fine of $5,000 and mandatory forfeiture of the weapon or device. The prosecution has charged you also as a habitual 4th offender, meaning that you have at least 3 either attempted or completed felonies in your past. That makes each one of those 5-year felonies punishable by up to life in prison. Do you understand those charges and the potential penalties?
Sure.
The court will continue the not guilty plea and continue the appointment of counsel. I will go through your rights with you. However, you do have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and the right to stop answering questions, and the right to be represented by an attorney. And if you could not afford one would be appointed to represent you, and Mr. Rupp has been appointed to do so. And that gets us to the probable cause conference. Counsel, has there been any resolution to this matter at all?
Judge, I did receive a proposed plea agreement. I discussed it the same with Mr. Couch yesterday afternoon via a Zoom meeting. We closed that meeting. He had a couple of questions regarding guidelines and a couple of potential sentencing issues. I wasn't able to answer them at that time. I was hoping I would have the opportunity to speak with him in a breakout room. So at this point, I don't believe we have a resolution, but I think resolution may still be possible. If the court is willing, I would propose converting next week's preliminary examination date to another probable cause conference so that I can arrange another meeting with him and answer those questions and allow him the opportunity to make an informed decision whether he wants to accept or reject the offer.
Mr. Carnes, do you have any objection to that proposal?
No objection, Your Honor. It does look like discovery was sent to Mr. Rupp about May 8th, and we did receive a new surveillance video on or about that date as well. So I think the adjournment request is reasonable. Thank you.
All right, the court will go ahead and reset this for another probable cause conference next week. Is there anything else we need to address for the record?
No, Your Honor.
No, the only other thing, Judge, I would just, for his edification, Mr. Couch, I will make arrangements for another Zoom meeting sometime this week to speak with you.
Sounds good.
Nothing
All right,
further,
thank
Judge.
you. All right, thank you. We'll see everybody back next week.
Very good.
Next is the people of the state of Michigan versus Wade Allen Schmidt Jr. All right, this is case number 26157 FY. Appearances, counsel.
Hey, Carnes, on behalf of the people.
I'm Jeff Harrison. I'm here on behalf of Wade Schmidt. Also present is his guardian, Jessica Starlin, and I never remember your actual last name.
Starling Ronan.
Ronan.
Thank you.
My apologies.
How you doing today, Your Honor?
How are you doing, Mr. Schmidt?
Pretty good.
Good. Counsel, we're here for a probable cause conference based on the sheet that was turned in. We don't have a resolution. Am I correct on that?
That's correct, Your Honor.
And Mr. Harrison, you are requesting a preliminary examination?
Indeed.
21 days is not waived, so are we going to be ready for a prelim next week?
I believe so, Your Honor. I would just request that the same nurse in this matter be permitted to appear at that preliminary examination via Zoom.
Any objection to that, Mr. Harrison?
Well, I don't like it, but I don't think I have a colorable legal objection to it. We don't have a right of confrontation in a preliminary exam.
No, but it is an evidentiary hearing, so
I would prefer that the witness be here in person, but I don't know that that's crucial to the court's determination. I'll leave it to your discretion.
Mr. Carnes, do you, the sane nurse, is she gonna have photographs and the like that she's gonna be testifying in regards to?
She does have a report that notates a couple of injuries. And Your Honor, I do have some photos. Honestly, I have not reviewed them, so I don't know who took the photos. But she certainly would be testifying as to some of the contents of her report.
And where is she coming from?
Travers
or Roscommon?
It was conducted in Roscommon. I think she might be.
Is it the same one?
Different, the different nurse.
Same organization?
Looks like even a different.
Okay.
organization.
All right, the court, given, while we might not necessarily be certain as to what exactly type of evidence will be presented, it is likely that the witness is going to have to testify to potential injuries, maybe some photographs. So I'm going to deny the request to appear by Zoom. I think this type of evidentiary hearing will best be served with in-person testimony. Anything else for the record?
I have nothing further, Your Honor. Thank you.
Mr. Carnes? All right, Mr. Schmidt, just a reminder that your bond conditions continue. You've been behaving on bond, so thank you for that. And the parties can go out to the front window where you checked in and get your next court date.
Most of us been using it playing video games. Works.
All right. Thank you.
That's a good work.
You have a good day, sir.
Thank you, you too.
I will.
Court next call is the people of the state of Michigan versus Robert William Gaston.
Well, the court may be calling somebody else, but we are going to move on, friends. Let's go back to Louisiana and give the board another try.
We're continuing our, the Committee on Parole in Baton Rouge, and you can see from our name tags who we are. We're continuing our hearings for the day. This is our second case. We're going to be hearing the case of Kayla Kuti Giles. If I'm saying that right, I'm probably not, but that's what we're going to be hearing. Someone with a similar name. Is Miss Giles there?
I am.
Okay, what is your DOC number?
768203.
Okay, and do you have a, okay, this is a parole hearing, so I'm sorry, we don't need to hear, it's not a revocation, so I don't need a form to be filled out. Okay, and you are at Louisiana Correctional Institute for Women, and we're going to take it like this. We're going to hear a little bit about what you did. We're going to talk to the warden or representative of the facility there about the kind of person that you've been since they've come to know you. And we're going to let Miss Jane Hogan, your attorney, wrap up things for the support end. Then we will turn it over to the opposition, and we have 3 people that will be speaking in opposition to the parole. And then we will finish that out with the attorney generals. Let's see, Mr. Joseph LeBeau, and he'll finish up, if that's okay with you. Yes, he'll finish it up, and then we'll ask questions and deliberate. So if you would, tell us what you did and why you feel like you're deserving of a parole.
Well, in 2018, I was at a custody exchange. My estranged husband tried to attack me when I was trying to leave. He jerked open my car door, so I shot him. Now, I was convicted of second-degree murder, and the Supreme Court overturned that conviction. It's worth noting that the justice even said that he may have done the same thing, and this was at oral argument. I wasn't charged with obstruction, which is what I'm here for today, until about a year later. And that stemmed from a phone call that I had with my sister, I want to say about a week or so after I was in jail. She asked what to do with a laptop that was in her possession that belonged to me. And she told me the police were not searching my home. So I told her, don't offer something that they're not looking for. My intent was not to obstruct anything or have her delete anything. It was really just so that I could have access to emails and my financial accounts online. I didn't think there was any harm in having access to those accounts. And so anyhow, she had given the computer to a friend of mine who was also taking care of my dog. And fast forward a year later, I get charged with obstruction. The prosecutor, Joseph LeBeau, I did hear him tell my attorney one time that if it were up to him, he would not have charged me with that was the doing of the former AG, Pat McGee. So I was kind of shocked that I'd received such a lengthy sentence for just that comment, which to me was harmless. I didn't have any ill intent in keeping, and I wouldn't have, if they would have asked for it, if I would have knew they were looking for it, then that would have been different. But they weren't searching the home, and I didn't feel that there was any need to just hand over the laptop without them asking. And I think it's also worth noting that I had all Apple devices. They had access to my cell phone. There was nothing that was on that laptop they could not view from the phone that was already in their possession. So again, I did not see anything wrong with what I had done.
Okay, thank you. We appreciate that rendition, and you're correct. You're not asking for parole on a homicide, and we understand that as a board. Okay, that's not on the table at this particular time. Okay, who would speak on behalf of the facility there? Who would be the one to speak?
It'd be me. I'm Deputy Warden Luke Reams.
Okay, Deputy Warden, would you tell us what she's been like since you've known her and since you've been in custody?
She's been held at LCIW since April of 22. She's completed numerous vocational schools. She's a couple self-help programs, rehabilitation, and she has 0 disciplinary reports. She's currently a medium level custody inmate, and she works in our canteen.
Okay. All right. We appreciate that. Okay, we'll move on to Miss Jane Hogan now. Miss Hogan, would you tell us what you've got?
Thank you, Mr. Prater, and good morning to the board. I've had the pleasure of representing Ms. Giles for a number of years. You are correct, Mr. Prater, that we are not here today for a parole hearing on the murder, which was vacated by the Louisiana Supreme Court. It is worth noting that in that opinion, the Supreme Court found that Ms. Giles, there was no evidence indicating that she was the aggressor, and so therefore giving the jury the aggressor doctrine was prejudicial because it negated a presumption of reasonableness that would have otherwise attached to Ms. Giles's actions, as we have standard ground law in Louisiana. So she's currently presumed innocent of that charge. She is pending a retrial in Rapides Parish. She looks forward to clearing her name for that charge, but we are not here today for that. What we are here for is the obstruction count. And as the warden has indicated, despite the unique circumstances of this case and despite the situation that Ms. Giles has found herself in, she has been a model individual. No disciplinary write-ups. She worked as a mentor in the intensive incarceration program. She took courses in moral compass and obtained a trade in welding. She's currently in the ServSafe class. She worked with the dog program and she worked in commissary for a number of years. So she has proven that she is able to follow rules, that she does not pose a threat. She has a low risk of recidivism if she is granted parole. And I would also like to mention that she has a detainer on her from Rapides Parish where she is pending retrial. So we are asking the board to parole Ms. Giles to that detainer so that this portion of her sentence, and it is also worth noting that the sufficiency of the evidence on the obstruction of justice conviction is currently pending before the Louisiana Supreme Court, as is the reasonableness of her sentence. So we don't yet know whether this obstruction count will be affirmed or will be ultimately vacated. So that is still pending. Also, this case is active on several levels. So what we are asking this court to do, this court has the ability to parole someone to the detainer, and we are asking them to do that. It's also worth noting that I know that the board mentioned that there are multiple people here to speak in opposition. We are not here for murder. We are here for obstruction, which is a victimless crime. So I would, I don't know who all is intending to speak in opposition to Ms. Giles, but I don't know that any of them, I would just caution that any opposition that is noted, that it be confined to the obstruction of justice count. That is why we are here today. So I'd ask the board to grant Ms. Giles's parole request to her detainer so that she can go back to Rapides Parish pending her retrial. Thank you.
Okay, thank you, Ms. Hogan, very much. Okay, we have the people here that are going to speak in opposition. We have Thomas Kuti. Mr. Kuti, if I'm saying that right, are you going to speak to us, sir?
Yes, sir.
Okay, would you go to the podium, please, and identify yourself and tell us what you have to say?
Good morning. My name is Thomas Kuti, September 8th, Caleb Trial, Mercer. Then she murdered Thomas. It's supposed to be a one field day, birthday party at Chuck E. Cheese for my granddaughter's second birthday. It turned out to be the worst day of my life. In Walmart parking lot, during the meeting to pick up my son's two stepdaughters to go to the birthday party, Tiger shot and killed my son cold blood in front of the three children.
Hey,
This
could I stop you for just a
Yes,
minute,
sir.
please, sir? I'd like I think we need to go into an executive session, if that's okay with you.
I'll second it.
I got a motion and a second and no opposition to an executive session. We're going to step to the back for just a moment and discuss a procedural matter that has to do with the taking of this testimony. Anyway, at the time it's 9:27 and we're going to step to the back for just a moment.
Okay, friends, we're actually in the Wayback Machine here just a little bit, so I'm going to push forward since we're getting close to the end of the hour so we can try to get this whole thing in. Yeah, right about here. We'll let it run from here.
So that is the moment my life changed forever since that day. I've been filled with sadness, anger, and grief. Thomas's death has left me the emptiness inside that will haunt me the rest of my days. Miss him so much. He was my only son, my child, and my friend. While Kayla was out on bail, awaiting the murder trial, she was granted permission by the judge to visit her son in Oklahoma. Only Kayla didn't go to see her son. Instead, she went to see one of her daughters who's a witness to the murder. Because she violated a court's order, her bond was revoked for contempt of court. On that same night, after leaving the state on February 7th, 2020, her house burned down. The fire marshal's office ruled the fire is intentionally set and suspicious of arson. It is still under investigation today. It was later found out that there was a suspicious fire at her house previous in Oklahoma during a divorce of her husband back in 2013. Later, in October 2020, when she was out on bail again, she was arrested and charged with felony identity theft, felony money laundering, government benefit fraud, and criminal conspiracy. Stealing the identities of approximately 25 people or more to file for fraudulent COVID-19 related unemployment claims valued at approximately $300,000. Taylor went to trial, and on January 29th, she was found guilty of second-degree murder, obstruction of justice. She was sentenced to life prison without parole plus 30 years. Because of appeals, she has been granted a retrial, and the trial is still pending. Kaylee is the definition of a sociopath. She is a danger to society with no regard for the law. To this day, she has shown no remorse for the murder of my son. Excuse me. Everything she does is for one or two goals: money or revenge. And I guarantee you that if she gets out on parole, she will strike again. And I say she will strike again. For this reason, I'm asking the parole board to keep Kayla locked up pending her upcoming murder trial. Thank you.
Thank you, sir. Sorry for your loss. Okay, let's hear from Miss Pamela Lafargue.
Dear honorable members of the Parole Board, I want to begin by introducing myself. I'm Pamela QT Lafargue. I was born and raised in Baton Rouge, went to LSU, graduated with a BS in finance. I am Tommy QT's first cousin. His son, Thomas Jr., I refer to him as T. How long have I known him? I've known him this long. This is a picture of his birth announcement. August the 17th, 1988. Tom T was more than family. He was more to my family than just our cousin. To my husband Craig and I, he was more like a son. We live in Baton Rouge, but we would visit family often in Alexandria and Pineville. We would stay in a hotel, and every time we drove up, T was already there waiting on us. He would stay with us for the whole weekend. He was 5 and 6 years older than my girls, but they grew up feeling he was more like their big brother. He was a blessing to us all. Doing research on what I was going to say, I came across Marcy's law that gives victims the opportunity to be heard at a parole hearing. So here I am. Very glad to have found this because sometimes it seems like the defendant has more rights than the victims. I still remember the day I got the call. I was out at LSU tailgating for an LSU football game. Had to walk away to be able to hear the call. Fell to my knees and began wailing in disbelief. He was the kindest, sweetest, compassionate, happy, honest, hardworking, funny, loving person who will never be replaced. There will never be another. He was so special. MMA was brought up at the trial. It has nothing to do with anger. It is merely a sport. He is a lover, not a fighter. He loved deeply, whether it was his daughter, family, racing, friends, or work. He touched so many. He will on in our hearts and our memories. It is so hard for me to describe the overwhelming emotion Tommy T's dad has felt since the day of the shooting. He's not the person he used to be. A part of him died that day alongside T. He's been grieving this whole entire time. His job now is to make sure he gets the justice we all deserve for our loss. Then maybe, just maybe, he can start to heal. I think closure for Tommy will be when he sees God's face. What do I want from this hearing? I want her to remain behind bars. The defendant gave T a life sentence, so that is what we want in return. Giles has shown time and time again that she doesn't respect or think she has to follow the laws. The obstruction charge accuses her of intentionally removing and hiding a bag from her house that had electronic evidence with the specific intent of distorting the results of investigating into the shooting. When investigators finally got the laptop, they found someone had been using it to search information of Louisiana's stand your ground and justifiable homicide laws. She fatally shot my 30-year young cousin in the chest that pierced his heart. She said she was scared because he called her the B word. She didn't even try to help him. She respected and would never put hands on a woman or any woman. It is also reported that none of the 3 girls were injured. Well, I beg to differ. Those girls will forever remember that day and the horror they witnessed. And poor Tessa, Dee's daughter, she will always remember that her birthday as the same day her daddy was taken from her. Here are more examples of Giles not following the rules and laws. A gag order exists in her case, and she still passed a letter to KALB TV through her sister. She wanted to contact media about the case, and the letter contained information concerning the case. Giles asked her friend of 17 years to borrow her gun to shoot T. Her friend testified to that. Also, there was evidence of Giles' recorded jail phone calls, one saying that she would leave the state if she got out of jail. She tried to conceal evidence of premeditation in a case in which she claimed self-defense. State ruled a fire was intentionally set at Pineville home of Giles and Thomas Jr. She had misused funds from the victim's account before his death. She also was granted permission to leave the state of Louisiana to visit her son and his father in Oklahoma. This did not include visiting one of her daughters who witnessed the shooting. Identity theft, domestic violence, and bragging on it, she said, quote, knocked the shit out of Thomas. It felt good though, end quote. Government benefits fraud, money laundering, tried opening a daiquiri bar when she was out on bond, and one condition was that she not visit bars or casinos, and on and on and on. I believe that there is undue risk that if she gets out on probation, Giles will commit another crime. The defendant is in need of correctional treatment, and a lesser sentence will deprecate the seriousness of her crimes. She was involved in multiple incidents for which sentences have not been imposed. Attorney General at the time, but now Governor of Louisiana, Jeff Landry, issued the following statement after his office obtained a conviction of Kayla Giles on charges of second-degree murder and obstruction of justice. Quote, today, justice was served to Kayla Giles by a jury of her peers in Rapides Parish. I pray her conviction provides some healing and closure to the victim's family. My office and I remain committed to doing all that we can to make Louisiana a safer place to work, live, worship, and raise families. Even Louisiana Attorney General Liz Morrell commented on the Supreme Court when they vacated the second-degree murder conviction.
Excuse me, Mr. Farr, would you kind of wrap it up for us, please? We got some other witnesses. that want to
Okay.
speak.
So once again, the outcome we hope for today is her parole to be denied and for her to maintain the maximum sentence. Thank you in advance for your consideration.
Thank you. I appreciate that. Appreciate it. I'm sorry for your loss also. Okay, Mr. Joseph LeBeau. Well, excuse me, not Megan Williams. Megan, would you talk to us, please?
Thank you. I'm writing this letter to regarding the hearing for Kayla Giles, who was convicted of serious crime, including obstruction of justice, identity theft, and is currently waiting trial for the murder of my brother, Thomas Jr. As a victim of myself and a family member of Thomas, I feel compelled to express my deep concerns about the possibility of granting parole to bail. The gravity of Kayla's actions cannot be overstated. The obstruction of justice signifies a blatant disregard for the legal process and the pain caused by the crime, while the identity theft highlights a troubling pattern of deceit and exploitation. Most alarmingly, the ongoing trial for my brother's murder casts a shadow of doubt and fear over the prospect of her release. The theft of my identity was a gratuitous violation that has caused my years of distress and complications. Beyond the immediate toll, I have faced practical challenges, including damage to my credit, legal intake, my wages garnished, and ongoing anxiety about my personal security. The effects of Kayla's actions are still affecting me today. My credit report has not been clear. My wages are still being garnished. The implications of identity theft is far-reaching, affecting not only my financial setting, but also my sense of safety and trust for the world around me. Moreover, Kayla's actions the day my brother died should not be overlooked. She put her own children at risk of being harmed, as well as having them witness her shoot Thomas. My brother's baby girl has lost her mama and her daddy that day on her second birthday. She will never have a happy birthday because of Kayla's selfish actions. She will never know how much her daddy loved her other than what we told her, because she was so young and he was taken away from her. While my brother lay dying in the parking lot, she was making calls to get rid of her computer and other evidence. Kayla showed no remorse or anything about her actions that day. I ask you to please think about that baby girl and the other two girls witnessing that heinous act of violence from their mother that day when considering her eligibility for parole. Releasing Kayla back into the community posed a risk not only to those who are connected to my brother, but to the public at large. The emotional and psychological toll that my family has endured since T's death is immeasurable, and safety remains of paramount concern. As a victim of her actions, I ask you to consider the severity of Kayla's crimes and the impact of her actions that have had on my family, and as well as her own children and the community. Thank you for your attention to this matter, and I trust that you'll make a decision that prioritizes justice and safety to our community.
Okay, thank you very much for that. And Mr. Joseph LeBeau, and if you wrap up those in opposition, we appreciate it, sir.
Thanks, sir. As members of the board, I'll try to keep my comments as brief as possible. I just want to start by saying that the suggestion that obstruction of justice has nothing to do with the underlying crime, and that it's a victimless crime, is both offensive and legally inaccurate. In fact, the sentence for obstruction of justice differs depending on what that underlying is. In this case, the defendant was convicted, has been found guilty by a jury, and twice by the Third Circuit Court of Appeals agreed that the evidence was sufficient of obstructing justice by tampering with evidence linking to the homicide. So I do think the homicide is wrong. I'm not going to go through the entire facts of that homicide. Needless to say, the state will absolutely retry that murder. And it is in fact pending as we speak. I think more importantly, though, is the statement of the defendant. Gentlemen on the parole board, you saw a person who has taken no responsibility for her actions, despite being convicted, has no remorse, and in fact has shown a propensity that she will in fact reoffend if granted. She was convicted while on bond, violated multiple court orders, and is continuing to deny any wrongdoing in this case. And I think that is the most important thing for the parole board to consider. There are alternative forms of relief here that are more appropriate. In fact, there is an appeal pending that Ms. Giles is pursuing. I think we can allow the Louisiana Supreme Court to make the decision as to whether or not that appeal is granted. and that the parole board should defer to the courts and allow that alternative form of relief. Alternatively, she's also eligible for good time at a date in the future. Less than 7 years into a 30-year sentence is not early enough. It would deprecate the seriousness of the offense. The fact that she was trying to hide premeditation evidence, communications regarding violence towards the victim of the homicide, as well as evidence of committing other crimes against the victim. So, gentlemen of the parole board, I would ask that you deny Ms. Giles' parole today and have her continue to serve. Thank you.
Thank you, sir. We appreciate that. And that concludes those that are going to be speaking in favor of this parole and those in opposition of parole. And we'll continue with Mr. Barra, who the case is assigned to him, to see if he's got any further questions or if he is ready for a.
Not many questions, but we also have in opposition here at headquarters, Miriam Kuti. We have also Jesmo Jones, opposition. We have Tucker Pearson with the AG's office, who's opposed and not speaking. We have Renee Weeks, who is opposed but not speaking. We have Catherine Pearson, who's opposed and not speaking, and Jeff Trailer, who's opposed and not speaking. Also in the case, we have real strong opposition from the law enforcement back in the Alexandria area and Baton Rouge area. And we have a strong letter from the Attorney General's office noting reasons why this parole request should be denied. I read through the case and all the reports, and I really don't have any questions additional. Does anyone else?
Gillis, any questions?
I have no questions.
All right. Without any further questions, I'll cast the first vote since it's assigned to me, and I vote to deny this request because of the law enforcement opposition and the continued threat to public safety and victim opposition.
All right.
My vote also is to deny, same as Mr. Barra.
Okay, and my vote is to deny also. I don't think that near enough time has been served on a 30-year sentence to begin with, and that's what I base my decision on, along with the opposition that's been mentioned. So as of today at 9:58, your parole has been denied. Thank you.
Well, I think at the very best we can describe that as messy. I kind of want to go back and listen to it again, and I kind of want to do some research because I feel like there's some finer points there that I had trouble wrapping my brain around. I don't know if you guys feel the same, but there was a lot of layers and a lot of complexity to everything that was going on there. Anywho, that brings us to an end for this morning. I hope you all enjoyed yourself. I do have homework for you, however. Especially if you're going to join us for sidebar tonight. So as soon as the copy and paste decides to work here, there we go. In the chat, I just dropped a link. This link is live for channel members right now. It'll be live for everybody in 2 hours. And it is the hearing that we saw yesterday in Judge Prill's court, the sentencing of that funeral home director. And that's homework for you to get up to speed in case you don't remember that case. You didn't see it on our live show yesterday for sidebar tonight, because that's what we're going to discuss. And that will be at 8 p.m. Eastern, 5 p.m. Pacific. So please do join us for that. If you just stick here, as soon as I end the stream, YouTube will send you over to that stream so you can set a reminder for that. Begin anywho, hope to see you tonight. If not, we'll see you tomorrow morning right here at the same time. In the meantime, go have yourselves a great day. Take care. God bless.